Everybody good? The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone to today's hearing on the adverse effects of Plyler v. Doe. I will now recognize myself for an opening statement. In 1975, Texas took a bold stand against illegal immigration after experiencing the adverse consequences of illegal immigration in its classrooms firsthand, recognizing the federal government wasn't doing enough to secure our borders. That same year, Texas passed a law to prevent illegal alien minors from crowding its K-12 public schools, prioritizing American students based on the belief that limited resources should benefit those with legal status, a point underscored by federal inaction. The law was challenged and eventually made its way to the Supreme Court in 1982, where 5 Supreme Court justices declared that Texas and every state in the union is constitutionally required to offer free public education to illegal alien minors. The case was called Plyler v. Doe. It's time for it to go. Without even a head fake towards the original meaning of the 14th Amendment or the court's Equal Protection Clause case law, the Plyler majority held that American citizens must subsidize the education of minors who are in our country illegally. At the outset, Plyler is constitutionally indefensible, having no basis in law or even common sense. The court's majority relied on 2 key premises. First, that illegal alien minors are not responsible for their immigration status, and second, that mandatory free education for illegal aliens does not burden states. The court referenced the Equal Protection Clause, a provision in the 14th Amendment that prohibits states from denying any person within their jurisdiction the equal protection of the laws. The 5-justice majority set aside every conventional tool of constitutional interpretation and simply wished a new right into existence by legislating from the bench using the Equal Protection Clause of the 14th Amendment as justification. It is absurd to claim that the drafters of the 14th Amendment understood it to guarantee public benefits to individuals who have no right to be in the country and whose very presence is a violation of American law. Plyler gets the constitutional basics wrong about what constitutes a right under the Equal Protection Clause. The 14th Amendment states that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. By definition, illegal aliens, including those who are minors, are trespassers to the nation, as they entered or overstayed without the consent of the American people, which makes them persons outside of the jurisdiction of the United States. Immigration, legal or illegal, is not a fundamental right. Congress establishes which aliens, how many of which, under what circumstances, if any, are allowed to enter and determines what they are entitled to once they are within our borders. Similarly, accessing public education is not a fundamental right, explicitly or implicitly guaranteed by the Constitution under the Equal Protection Clause. In other words, the Supreme Court majority in Plyler based part of its ruling on a misguided premise that unchecked immigration and education somehow mandated by the 14th Amendment. Just as important, the court's majority claimed that the number of illegal aliens in public schools in Texas was small, and that there was no evidence in the record suggesting that illegal entrants impose any significant burden on the state's economy. That premise fails on 2 fronts. First, any amount of illegal immigration in our hospitals, jails, schools, or elsewhere should not be tolerated and definitely represents a significant burden on taxpayers. And second, states should have the ability to curb it. Texas' experience with the negative impacts of illegal immigration in its classrooms since the 1970s, requiring state funds from law-abiding residents, exemplifies why states should have legislative options to address these costs. Moreover, and fundamental to the issue at hand, the facts surrounding illegal immigration to Texas and nationwide have worsened since 1982. For starters, our nation's illegal alien population was roughly around 3 million in 1982, has skyrocketed to an estimated 15 to 20 million last year, meaning we have 5 times the number of illegal aliens we had 40 years ago. As of 2025, Texas had more than 2.7 million illegal aliens residing across the state, draining public resources and services. So what's to blame for this surge of immigration lawbreakers? Up until President Trump returned to office, the federal government had refused to take seriously its most basic responsibility of securing our borders. The federal government has also issued more amnesties, both at the congressional and executive branch levels, that have shielded millions from deportation, incentivizing more of the same lawless behavior. At the state level, we've seen localities issue more magnets that attract illegal immigration, not fewer, such as offering taxpayer-subsidized benefits to illegal aliens. More recently, we've had activist judges strike down legally sound policies aimed at putting Americans first. By any objective measure, the America we live in today, with an exponential growing significant burden on local resources and failed federal immigration policies, demonstrates that the effects of the Plyler decision have become worse since 1982. To add to the problem of illegal aliens in our schools, we've been met with unaccompanied alien minors who have traveled across the globe due to failed policies under the previous administration and under other Democratic regimes, are ordered to be released into the interior thanks to exploited laws. Over the last decade, more than 700,000 unaccompanied minors have crossed the border illegally, which, by the way, endangers the children, in addition to providing a burden on our schools and on our systems in the state of Texas. American taxpayers provide free public education to every single UAC enrolled in a public school. And I can tell you firsthand in Texas, the burden that is placed on the people of Texas, the taxpayers of Texas, our local jurisdictions, because of these failed policies, and because of a Supreme Court ruling that we have no business continuing to operate under. In Cleveland, Texas ISD, where once 40% of its 3,500 students were Hispanic, today 90% of its 10,800 students are Hispanic, many of whom do not speak English. This has led district to hire foreign-born teachers through specialist work visas to teach ESL classes to immigrant students. Student enrollment in Cleveland ISD is set to double this year, with a projected price tag of $1.2 billion over the next decade. A public school in Houston, named Las Americas Newcomer Middle School, started a semester with 150 immigrant and refugee students, and the following year was 325. Principal Maria Moreno said of the situation, "It's put a burden on me because I've run out of space. I can't handle them. They're going next door to another school." Since 2015, over 98,000 unaccompanied alien children have been released to sponsors in Texas, adding more illegal alien minors to our schools. Based on Texas' average per pupil spending of $13,900, just 1 year of public education of these alien children cost Texans $1.3 billion. Nationwide, the cost to help alien school children, legal immigrant minors, and refugees learn English through limited English proficiency programs in American schools is $78 billion annually, according to a 2022 study. All the while, the American taxpayers left with the bill to pay for the education. The financial costs of Plyler are undoubtedly staggering, clearly representing a significant burden on localities. But it isn't just fiscal costs we should be worried about. Our nation's classrooms routinely deal with illegal alien students, many of whom know little to no English, and may struggle with other learning disabilities. For example, a 2017 study by the Annie Cassie Foundation revealed that immigrant children, legal or illegal, had lower reading and math proficiency scores compared to their American board classmates. The study found that among fourth grade children from immigrant families, only 8% scored at or above the proficiency level. In math, proficiency rates are even worse. Such data should prompt a broader discussion about the demands placed on schools and educators who must use limited resources meant for American students by American taxpayers to help immigrant children achieve proficiency standards. In the small community of Charleroi, Pennsylvania, if I pronounced that right, Charlotte, an influx of illegal, it's Pennsylvania, so it's closer than it is to Austin. An influx of illegal alien Haitians led to a complete disruption of the educational environment. In the 2021 school year alone, the number of non-English speaking students skyrocketed from 12 to 220 in a district of only 1,450 students. Teachers had to pause in the middle of lessons to translate using phone apps, leaving one wondering if she was hindering the learning of American students. Today, this small industrial town spends $400,000 annually on 5 staff members dedicated to non-English speaking aliens. Similarly, in a single year, Maryland saw more than 2,200 unaccompanied minors arrive, posing burdens on the school administrators. In Miami-Dade County, in public schools reporting spending $1,959 more per child for immigrant children and are reliant on community partnerships. I could go on with examples of this absurdity across the country. Ironically, writing for the majority opinion for Plyler, Justice Brennan wrote that such policies allowing illegal aliens access to public schools could likely lead to, quote, the creation and perpetuation of a subclass of illiterates within our boundaries, surely adding to the problems and costs of unemployment, welfare, and crime. Fast forward 40 years, the American students, teachers, and taxpayers are living with the unmitigated consequences of that ruling. State governments and Congress have restricted illegal aliens from accessing SNAP, Medicaid, in-state tuition, among other benefits in the past. It can certainly deny access to their public classrooms. Unelected federal judges should not interfere with rulings based on personal policy preferences not rooted in the Constitution. In fact, my legislation, H.R. 6225, the PAUSE Act, would freeze immigration until the federal government fixes longstanding illegal immigration problems ranging from birthright citizenship to issues such as the one we're discussing today under Plyler v. Doe. It's time we meet the moment to overturn Plyler v. Doe. It's time for Congress and the courts to address the glaring failures of this court decision and finally alleviate Texans and Americans alike from this burden. And with that, I will recognize the ranking member for her opening statement.
Thank you, Mr. Chairman. 50 years ago, Texas passed a law seeking to ban children who were not legally admitted to the country from our public schools and to defund their education. The state argued that this ban was necessary to preserve its resources for educating its lawful residents and argued that these children were not persons under our Constitution. The Supreme Court disagreed. In 1982, the court struck down the Texas statute in Plyler versus Doe, rejecting the argument that children did not count as persons entitled to equal protection under the 14th Amendment. The court also found Texas's economic arguments to be unconvincing, and the exclusion of undocumented children from public schools an unlikely and ineffective way to achieve the true underlying objective of addressing and ultimately repelling an influx of undocumented immigrants. Even conservative Chief Justice Berger, while rejecting the majority's reasoning, wrote, quote, "It is senseless for an enlightened society to deprive any children, including illegal aliens, of an elementary education," end quote, and agreed that, quote, "It would be folly and wrong to tolerate creation of a segment of society made up of illiterate persons." He also noted that, quote, "The long-range cost of excluding any children from our public schools may well outweigh the costs of educating them," end quote. For a generation, the issue was deemed settled, but bigotry and bad ideas die hard. Now, at the urging of the Trump White House, the authors of Project 2025, and their allies, Texas and a few other states seek once again to enshrine bigotry and bad ideas into law. To do so, they've mounted a coordinated effort to overturn Plyler versus Doe, making the same arguments that the court previously rejected. But if anything, the intervening years have put to rest the argument that the public education of undocumented children imposes a net economic burden upon the states, or somehow harms public education and services offered to lawful residents. In fact, the overwhelming majority of credible studies from both conservative and mainstream entities, including the Congressional Budget Office, have consistently found that the net economic impact of immigration is overwhelmingly positive. Most recently, the Congressional Budget Office issued a finding that immigrants, including undocumented immigrants, generated a $14.5 trillion, that's trillion with a T, fiscal surplus over the last 20 years. When one compares the tax contributions of those immigrants to the limited, very limited public benefits that they consume, even in Texas, the purported subject of this hearing, the net fiscal impact of immigration during the 40-year Plyler period, including the cost of public education, has a net of $93 billion to the benefit of the state. In addition, we now have decades of data showing the public health, developmental, civic, humanitarian, and social impact of providing public education to immigrant children regardless of their legal status. No matter the rhetoric coming from the other side of the aisle, the fact is that our Republican colleagues have brought us here today to advocate for kicking kids out of school. Reversing Plyler versus Doe would mean that children as young as kindergarten and through high school would be denied a basic education, left out of society, and held back from reaching their potential and meaningfully contributing to America. This isn't just terrible education policy. It's extremely harmful to vulnerable children. It's also bad for our country's health, workforce, and economy. The Supreme Court's decision in Plyler versus Doe guaranteed equal access to free public K-12 education for all children living in the United States, regardless of their immigration status. The court recognized in Plyler that education provides the basic tools by which individuals might lead economically productive lives to the benefit of us all. And in the 44 years since, the children who've benefited from these protections, including some who have since become citizens and legal permanent residents, have grown up to contribute immensely to our country. A report by FWD.US found that Plyler beneficiaries have driven economic growth by paying over $633 billion more in state and local taxes than their public education's cost, preventing over 700,000 U.S. citizen children from falling into poverty, increasing GDP by $2.71 trillion over their lifetimes. These are, again, the accomplishments of the Plyler beneficiaries. They've strengthened the workforce with over 1 million people filling U.S. jobs, and they've reduced healthcare costs by at least $28 billion since 1982. Additionally, other students have found that having immigrant children in K-12 classrooms improved the academic outcomes for their U.S.-born classmates, lifting up entire communities. Public schools are a crucial part of our social fabric. They're places where kids can learn, make friends, dream about their futures, and develop the skills they need to contribute to those futures and our society. Robbing some children of that foundation would wind up hurting all children and America as a whole. It's a cruel attempt to senselessly punish undocumented children for their parents' decisions, choices they had no role in. And it's all based on a false assertion that giving undocumented children a public education is a burden on taxpayers. It bears dangerous similarity to other attempts to exclude children, including children with disabilities, from public education. According to a June 2025 analysis from Niskanen Center, the tax revenue from undocumented workers alone covers the annual cost of educating undocumented children. Of course, the effort is part of an ill-conceived effort to end immigration to this country, a country that is famously one formed by immigrants. But it's also part of a larger war on children being prosecuted by this White House. A right-wing effort to kick kids out of school is just another facet in the ongoing war that is being waged against American children, particularly the effort to undermine public education. President Trump and congressional Republicans' One Big Ugly Bill ripped health care and food away from millions of kids when enacting the biggest cuts to Medicaid, CHIP, and SNAP in our history. This administration is attempting to undermine and erode vaccine science at a time when measles and other preventable infectious disease outbreaks have killed American children. And Republicans have made callous cuts to childhood cancer research, denying families the hope of a cure. This administration has decimated the Department of Education, gone after funding for early childhood education programs like Head Start, frozen access to billions of dollars in funding for child care and family assistance, and cut funding for community violence prevention. ICE is now targeting schools, previously protected areas, in its cruel, chaotic mass deportation efforts, leading to plummeting attendance and fear among entire school communities. Children have been detained in traumatizing conditions and used as bait by immigration enforcement agents to lure their parents. Some of us may remember growing up and learning about when in the Bible Jesus said, "Suffer the little children to come to me," rejecting the efforts of his disciples to punish their parents' efforts. But right now, instead of caring for the little children, our country and its leaders are shamefully turning their backs on those little children. We must firmly reject a worldview that only certain classes of children, those whose parents can afford to pay, are entitled to the blessings of liberty and the hope of a better future. Our kids are our future, and I want to do all we can to make sure that that future is a bright one for everyone's sake. So this is not the direction that we need to go back here. It's fundamentally flawed. I yield back.
I thank the ranking member. I believe for the sake of time, the chairman is going to yield, and I will recognize the ranking member of the full committee, Mr. Raskin.
Thank you kindly, Mr. Chairman, and thanks to the witnesses for being here, and thanks for these wonderful kids in the front row who are keeping me very entertained. I wanted to start by invoking Tom Paine, who was an undocumented immigrant who came to this land in 1774, 2 years before the Revolution, and wrote Common Sense, the pamphlet that ignited the American Revolution. And he said that this land, if it lives up to its ideals and its promise, would become an asylum to humanity he said. Not an insane asylum, but a place of refuge for people seeking freedom from religious and political, intellectual, and economic persecution from all over the world. Also in the 18th century, Thomas Jefferson, who was a descendant of a long line of undocumented immigrants, both on his mother's side and his father's side to the country, said that education would be central to democratic self-government and to the protection of liberty in our country. He said that a nation cannot be both ignorant and free. He said it was an impossibility. In the 20th century, the Supreme Court affirmed that public education is a constitutional commitment in America for all children who are here. In Plyler versus Doe, the court held that denying children access to a public education based on their immigration status would violate the 14th Amendment Equal Protection Clause. Writing for the majority, Justice Brennan found that excluding undocumented children from public education would impose a lifetime of hardship. He said, something like what the Constitution calls a taint of blood or a bill of attainder, a hereditary punishment for something over which the child had absolutely no control. Plyler did not place an undue financial burden on America. Rather, it has paid big dividends for our country. A recent analysis measured the costs and benefits of this decision and found that children who are able to go to school thanks to Plyler have contributed to the tune of billions of dollars more in state and local income taxes than the costs of their education. And of course, their classes were going to be happening anyway. Plyler has strengthened the workforce by allowing 3/4 of adults who got an education, thanks to Plyler, to work in occupations that require a high school degree. And it's also improved public health by making sure that every child in America gets the appropriate vaccinations. So is there anyone who really thinks that America would be stronger as a country if all of the kids who got an education because of Plyler versus Doe had been forced to stay home or to stay in the streets during the day when their parents were working? Well, in order to distract America from the Iran war, which is now costing between $1 and $2 billion a day, and which has already cost 13 Americans their lives and more than 1,000 Iranians their lives, including 175 school children who perished in a bomb explosion at an all-girls school. In order to distract America from the Trump administration's massive cover-up of the Epstein files and the billion-dollar global trafficking conspiracy of young women, teenage girls, and children, our colleagues want to revisit a 44-year-old Supreme Court decision with the aim of kicking tens of thousands of kids out of their classes and out of their schools. Well, the Trump administration's mass deportation campaign is already succeeding in denying kids, both non-citizens and citizens alike, access to school and education. In a survey of 693 educators across the country, when asked whether federal immigration enforcement efforts were affecting students, 24% reported reduced student attendance at school and increased distraction or disengagement in class. 18% said reduced attendance is leading to declining student performance, of course, and 50% stated that the children in their schools have expressed great anxiety and fear about what's taking place in their communities. The harm is not concentrated solely in the cities most under siege either. West of the Twin Cities, in Wilmar, Minnesota, more than 1 in 4 students started missing classes after one student with legal residency was detained and held in custody for several days, and another student, who's a U.S. citizen, was stopped by ICE outside a district learning center. The school superintendent said, quote, "Families of our black and brown students feared profiling and family separation, even as legal residents. White families reported keeping children home due to anxieties about potential armed law enforcement activity taking place inside the schools. And even when kids are showing up, immigration enforcement actions are dramatically affecting academic performance. Using data from a large urban school district in Florida, one of the 10 biggest in the country, researchers found that the recent surge reduced test scores for both US-born and foreign-born Spanish-speaking students, especially in higher poverty areas. It is hard to study, to learn, to think, to do homework, or to take exams when you are filled with fear and dread and anxiety. This reign of terror is part of the administration's relentless campaign against children right now. In July last year, Trump signed into law his big, beautiful bill, which included the largest cuts to Medicaid, the Children's Health Insurance Program, and the Supplemental Nutrition Assistance Program, SNAP, in our history. Over 37 million children rely on Medicaid and CHIP to get health care, and nearly 15 million children rely on SNAP to get adequate nutrition. While denying children access to health care, the administration is also making it harder for kids to stay healthy in the first place. After a confirmed 2,144 measles cases across 44 states in 2025, the U.S. stands to lose its measles-free designation. With this self-inflicted wound, administered by Secretary Robert F. Kennedy Jr., the country is already on track to soar past last year's total measles cases, with more than 1,300 cases across 31 states already confirmed as of March 12th. And of course, Mr. Chairman, Texas has been particularly hard hit. The Secretary of Health and Human Services fired all 17 members of its Advisory Committee on Immunization Practices, which provides recommendations for immunization in the U.S., and dropped the number of recommended routine childhood vaccines, putting children again at risk of contracting preventable diseases. The administration has gutted the Department of Education, which ensures nearly 26 million low-income students and 7.5 million students with disabilities get meaningful access to educational opportunity, and has repeatedly threatened funding for Head Start, which provides childcare and early education to millions of low-income children every year. I would urge our colleagues to abandon this determination to make life harder for children in our country, and instead join us in passing policy to deliver for America's kids. Together, we can make the child tax credit permanent instead of making tax cuts permanent for the nation's billionaires. We could expand access to health care and support for nutrition for kids in need. We could protect the Department of Education to make sure kids in America get equal access to a quality education. We could take action to once and for all address the leading cause of death for children under 18 in the United States, the epidemic of gun violence in our country. For more than a decade now, Americans have strongly supported common sense gun safety reform to ensure that guns stay out of hands of the people who do the most harm. Yet no matter how many children lose their lives to gun violence, our colleagues maintain their oath to the gun lobby and the absolute myth that the Second Amendment prevents reasonable gun safety legislation. It does not. The Democrats on this committee take supporting and protecting every child in America seriously. I hope our colleagues will join us. Thank you, Mr. Chairman. I yield back.
Thank the ranking member. I'll remind people this is a hearing on Plyler v. Doe. Now, without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Ms. Mandy.
I was just curious. The ranking member said, I think his opening sentence was, he said Thomas Paine was an illegal immigrant. My understanding was Mr. Paine was born in the UK, came to America, then a British colony in 1774. So I was just struggling to figure out how he was.
Oh, I didn't say he was an illegal immigrant. I said he was an undocumented immigrant, just like Thomas Jefferson's family was. Most of our ancestors did not arrive here with documents.
Okay, well, big deal. Okay, got it.
Well, it does appear to be a big deal to people on your side of the aisle because you don't want to educate kids because they don't have the right documents.
It's the time of the chairman. The chairman's going to yield back, and I would just note it's not undocumented because he was within the colonies of England. He was a citizen of England. All right. Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Ms. Mandy Drogan. Ms. Drogan is a senior fellow with the Government Reform and Oversight Coalition at the Texas Public Policy Foundation. Her work focuses on K-12 education. She previously worked at the American Federation for Children. Mr. Matt O'Brien. Mr. O'Brien is the Deputy Executive Director of the Federation for American Immigration Reform. He previously served as an Assistant Chief Immigration Judge, Chief of the National Security Division of U.S. Citizenship and Immigration Services Fraud Detection and National Security Directorate, and in other senior roles in USCIS, ICE, and what was then known as the Immigration and Naturalization Service. Mr. James Rogers. Mr. Rogers is Senior Counsel at the America First Legal Foundation, where he litigates matters involving border security, election integrity, parental rights, and constitutional administrative law. He previously served as Senior Litigation Counsel in the Arizona Attorney General's Solicitor General's Office. Mr. Thomas Saenz. Mr. Saenz is the President and General Counsel at the Mexican American Legal Defense and Educational Fund. He previously served as counsel to then Los Angeles Mayor Antonio Villaraigosa. We thank our witnesses for appearing today and will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you. You may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Ms. Drogan, you may begin, and I will remind each of you to turn your microphones on before you begin your testimony. Ms. Drogan, you may begin, and you have 5 minutes.
Chairman, Ranking Member, and members of the committee, thank you for the opportunity to testify on the adverse effects of Plyler v. Doe and how subsequent federal policy, particularly the Obama administration's Dear Colleague letter, has created a contradiction harming students, schools, and communities. Plyler v. Doe held that states cannot deny illegal immigrant children access to public education. Texas has fulfilled that obligation. Our Constitution requires a free public education system, and Texas has built one of the nation's most robust accountability systems in the nation. Our A through F accountability system evaluates schools based on standardized test performance, graduation rates, and college readiness indicators. These ratings have real consequences. They can trigger state interventions, leadership changes, campus restructuring, and school closures. In recent years, roughly 16.6% of Texas districts have received a D or F rating. The ratings drive major policy decisions like student funding, and it relies on accurate demographic data. Yet federal policy prevents states from collecting one key category, the illegal immigration status of K-12 students. FWD.US estimates that approximately 111,000 students in Texas are illegal immigrant children. This restriction does not come directly from Plyler v. Doe. Instead, it stems largely from a 2011 Dear Colleague letter issued by the Departments of Justice and Education, which warned that asking about immigration status could discourage enrollment and create a chilling effect. The Dear Colleague letter is agency guidance. It's not law passed by Congress, and it is not required in Plyler or by the Supreme Court. Congress should clarify that it cannot prevent states from collecting necessary data to educate students. Every effective education policy relies on demographic data. Schools identify student populations to provide targeted support, whether it's for low-income students, English learners, or students with special disabilities. And they track things like race, gender, attendance, discipline, and even parental incarceration. This data is used to identify needs and measure outcomes. It is not used to stigmatize students. It's universally accepted that schools must have it to identify student needs, measure outcomes for the students, the schools, and the entire education system. Yet, illegal immigration status is the one characteristic schools are effectively barred from measuring. States are asked to address complex challenges while remaining blind to a key factor influencing outcomes. This contradiction undermines the very logic of Plyler itself. If illegal immigrant children face serious disadvantage, as the court has recognized, schools must be able to identify them in order to provide appropriate supports. Evidence suggests illegal immigrant students face challenges way beyond language barriers, including higher absenteeism, mobility, interrupted schooling, and greater educational needs. A study in social science and medicine found that 97.4% of Central American and Mexican migrant children experienced at least one traumatic event before entry, and 44% showed psychological or behavioral concerns. Texas medical experts report many require significant mental health support due to sexual and violent trauma experienced during migration. These realities affect accountability systems and other students as well. Schools must determine whether performance challenges stem from language barriers, trauma, or interrupted education, but policymakers cannot answer these questions on how illegal immigrant students perform as compared to other groups. We see the consequences all across Texas. Campuses receiving failing ratings for 5 consecutive years face closure, restructuring, and state takeover. Recently, districts such as Fort Worth, Beaumont, Connolly, and Lake Worth ISD have faced such risks after 6 campuses repeatedly received failing grades. These campuses share strikingly similar characteristics. Between 80 and 97% of the students come from low-income households, compared to 60% statewide. At 5 of the campuses, 64 to 92% of students are considered at risk of dropping out. A Stanford education researcher, Beth Schuler, explained, quote, "I don't think we want to lose sight of the fact that demographic composition of a school system is the thing that's going to be most predictive of variation in performance and outcomes," end quote. When schools struggle or close, communities are disrupted, enrollment declines, families move, and local economies suffer. In short, the downstream effects of Plyler v. Doe affect every single student in the state of Texas, in the schools and in the community. It's not just the illegal immigrant students. Congress should require the Department of Education and Justice to issue new guidance clarifying the 2011 Dear Colleague letter can't prevent states from collecting data on illegal immigration or legal immigration status of students. Congress should also pass legislation allowing states to collect immigration status, both legal and illegal. If states are required to educate illegal immigrant students, they must be allowed to identify the student population status to fully understand and address the adverse effects of Plyler v. Doe. Thank you, and I look forward to your questions.
Thank you, Ms. Drogan. Mr. O'Brien, you may begin, and remind you to turn your microphone on.
Chairman Roy, Ranking Member Scanlon, and members of the subcommittee, thank you for the opportunity to testify. The Supreme Court's decision in Plyler versus Doe rewrote rather than interpreted the Equal Protection Clause. By transforming a Texas funding provision into a nationwide mandate, the court required states to provide free K-12 education to children who have no legal right to be in the United States. The majority did not rely on established constitutional doctrine. Instead, it imported its own policy preferences, particularly concerns about illiteracy and social mobility, and constructed a novel, heightened standard of review that the court itself admitted does not ordinarily apply to non-suspect classes or non-fundamental interests. The result was an act of judicial legislation that intrudes on Congress's plenary authority over immigration, restricts state control over limited educational resources, and imposes heavy fiscal and operational burdens on already struggling school systems. For more than a century, the Supreme Court has consistently recognized that immigration is a uniquely federal domain entrusted to the political branches. Congress may draw distinctions between citizens, lawful residents, and those here in violation of federal law. Indeed, the court has repeatedly affirmed that Congress has no constitutional obligation to extend public benefits to individuals who lack lawful status. When Texas in 1975 enacted a statute limiting the use of state funds to educate only children legally admitted to the United States, it acted squarely within this constitutional framework. Nevertheless, the statute was challenged under the 14th Amendment, and the Plyler majority ultimately struck it down, not on legal grounds, but on speculative policy judgments about social equity and long-term socioeconomic outcomes. The court acknowledged that illegal aliens are not a suspect class and that education is not a fundamental right, yet it proceeded to treat both as if they were, devising a bespoke standard of review applicable only to the facts before it. This approach was inconsistent with precedent, inconsistent with the Constitution's text, and inconsistent with the judiciary's proper role. Under ordinary rational basis review, a state may allocate its resources in any manner reasonably related to a legitimate governmental interest. But the Plyler court replaced that deferential standard with what legal scholars call rational basis with bite, forcing Texas to justify its policy as though a fundamental right were at stake. In doing so, the court substituted its own policy views for those of the legislature and entered an area, immigration policy and resource allocation, where the Constitution explicitly entrusts authority to elected officials. The consequences of this judicial overreach have been substantial. Plyler effectively created a federalized, unfunded mandate requiring states to provide free K-12 education to all children lacking lawful presence. Today, state and local governments collectively spend tens of billions of dollars each year to comply with this mandate, even as many public schools struggle with overcrowding, limited resources, and declining performance. Estimates indicate that between 1.9 and 2.2 million illegal alien children are now enrolled in America's public schools, many of whom arrive with significant educational needs that require additional staffing, specialized instruction, and expanded support services. These obligations fall squarely on state and local budgets, which already devote more resources to K-12 education than any other expenditure category. In sum, Plyler v. Doe represents a dramatic departure from constitutional principles, established doctrine, and the proper limits of the judicial role. By elevating policy considerations above legal analysis, the court imposed long-lasting financial and operational burdens on states and localities while undermining democratic accountability. Rather than upholding the Constitution, Plyler exemplifies the risks of judicial lawmaking and has had enduring negative consequences for both constitutional governance and the effectiveness of the American public education. Thank you. I look forward to your questions.
Thank you, Mr. O'Brien. Mr. Rogers, you may begin.
Chairman Roy, Ranking Member Scanlon, and members of the subcommittee, thank you for this invitation. In 1982, the Supreme Court held in Plyler v. Doe that states must provide free public K-12 education to children illegally present in the United States. That decision was wrong, it should be overruled, and even in the meantime, states are not without tools to address it. Plyler presented the court with a straightforward constitutional question. Under the Equal Protection Clause, courts apply strict scrutiny when a law discriminates against a suspect class, such as based on race or religion, or burdens a fundamental right, such as the right to freedom of speech or religion. Laws rarely survive strict scrutiny review. For everything else, courts apply rational basis review, which is a permissive standard that laws almost always survive. The standard of review that courts apply usually determines the outcome. As Mr. O'Brien acknowledged, the Plyler majority conceded that the heightened standard of strict scrutiny did not apply. It acknowledged expressly that illegal aliens are not a suspect class and that education is not a fundamental right. Having made those concessions, the court was legally obligated to apply rational basis review, under which Texas's law would easily have survived. Instead, the majority invented a novel substantial state interest test found nowhere in prior precedent, then used that invented standard to strike the law down. As Chief Justice Berger wrote in dissent, quote, "If ever a court was guilty of an unabashedly result-oriented approach, this case is a prime example," end quote. The decision was a close one, with only 5 justices in the majority and 4 justices dissenting. The dissent's core critique was that the majority had ignored the requirements of the Constitution and was substituting its own policy preferences for those of the Texas legislature. It was trying to address a perceived failure of Congress to deal with illegal immigration rather than allowing the political branches of government to fulfill their functions. The Constitution, Berger wrote, does not make justices into platonic guardians authorized to strike down laws that do not meet the court's standards of desirable social policy. The dissent also correctly pointed out that it is rational for a state to conclude that it does not have the same responsibility to provide benefits for persons whose very presence in the country is illegal. In Dobbs versus Jackson Women's Health Organization, which overruled Roe versus Wade, the Supreme Court articulated 5 tests for whether prior precedent should be overruled. Plyler fails every one. It was egregiously wrong from the start. The majority itself conceded that prior court precedent required that the Texas law be upheld. Plyler's reasoning is thin, lacking any grounding in constitutional text or history. Its substantial state interest standard is unworkable. No court has coherently defined it in 40 years. It has distorted immigration federalism by chilling legitimate state policy choices, and it implicates no concrete transactional reliance interest of the kind that the law is designed to protect. Critically, Plyler's own majority acknowledged that quote, undocumented status coupled with some articulable federal policy might enhance state authority, end quote, and thus justify the type of policy that the Plyler court had rejected. Congress has since provided exactly that policy. The Personal Responsibility and Work Opportunity Reconciliation Act of 1996, or PERORA, declared it a compelling government interest to deny public benefits to illegal aliens, and it barred them from federal public benefits. The premise on which Plyler rested thus no longer exists. Some states have started considering adopting laws that would bar illegal alien children from receiving free public education. They are trying to create a vehicle for the Supreme Court to reconsider Plyler and overturn it. Congress can accelerate reconsideration by enacting legislation explicitly authorizing states to condition free K-12 enrollment on lawful presence. Even under Plyler, meaningful tools remain. States can condition free public education on residency and then define residency as requiring lawful presence. Plyler bars denial based on immigration status, but a state that conditions enrollment on legal residency raises a fundamentally different question. States can also require districts to collect and publicly report the fiscal costs of illegal alien enrollment, building the evidentiary record for future litigation. Finally, they can restrict supplemental programs beyond the basic K-12 curriculum and deny in-state post-secondary tuition in compliance with federal law. In conclusion, as Chief Justice Berger wrote in his Plyler dissent, quote, "The Constitution does not provide a cure for every social ill," end quote. The court should correct its 1982 error. In the meantime, the states and Congress can take action to keep illegal aliens from taking advantage of the generosity of the American taxpayer. Thank you.
Mr. Rogers, thank you. Mr. Saenz, you may begin.
Thank you, Mr. Chair, honorable members. My name is Thomas Saenz, and I have been for 17 years now the President and General Counsel of MALDEF, the Mexican-American Legal Defense and Educational Fund. I am proud, as the current head of MALDEF, that my predecessors were the legal representatives for the plaintiffs in Plyler versus Doe, the first of a number of cases consolidated and coming before the Supreme Court in 1982. It's important to note that the Plyler versus Doe decision was the product of a conservative Supreme Court. Indeed, 4 of the 5 justices in the majority, including the author of the opinion, William Brennan, were appointed by Republican presidents. In addition, it's important to note that the swing justice, if you will, Lewis Powell, has impeccable conservative credentials, and he is clearly the justice whose decision ended up being the decision in Plyler. He was the 5th vote. But it's also important to note, as not often remembered, that while this court split 5-4 on the constitutional issue, the court was unanimous in its conclusion that the Texas law struck down was bad public policy. I say that because Chief Justice Warren Berger, who wrote on behalf of all of the dissenters who joined his opinion in full, including the soon-to-be Chief Justice, conservative William Rehnquist, on behalf of all of them, he stated that this Texas policy was a bad public policy. He called it folly. It's important to keep that in mind as you review the basis of the majority decision in Plyler. In Plyler, the majority simply applied rational basis, a standard recognized by the Supreme Court previously and all the way up to date, as a basis for evaluating legislation that singles out a particular group of persons for exclusion from a public benefit. In this case, excluding minor children who are undocumented from receiving public education. In applying rational basis, the majority considered a number of factors. Among them are factors that have clearly not changed in the 44 years since Plyler was decided. First, the fact is, as the court noted then, many of the students who are undocumented today and who would be deprived of a basic public education were the Texas law to be revived, many of those students will remain in the country indefinitely or permanently and will adjust their status to that of either lawful permanent resident or naturalized U.S. citizen. As such, they will be expected, as Brandon noted, to contribute to our economy, to our society, and to our government. Their ability to do so, if deprived of a basic public education, would be taken away from them. Second, court did recognize that public education is expensive, and that's the case today as well. However, despite that fact, public education is perhaps the government service that receives the highest levels of support throughout the country. Why is that? Because that expense is an investment. It is an investment that pays off. Having these children in school with a basic education when they become citizens or lawful permanent residents and are contributing to the economy pays off much more than the costs of the education. Billions, and indeed over time, trillions of dollars more into the economy, into government through tax payments, and through immeasurable benefits such as patents, innovations, and improved service throughout the economy. The court also recognized that these children are not responsible for their status in this country. They are minors. We're talking about elementary and secondary school children who came to the country as a result of decisions by their parents. That is still true today. Despite the slight increase in unaccompanied minors, The fact is the vast, vast majority of undocumented students did not come to the United States on their own. Finally, the court recognized, and I note here that Lewis Powell's concurrence particularly focused on what would happen if the Texas law were implemented. It would leave thousands and thousands of children on the street during the daytime rather than being in school. Well, the Plyler decision didn't explore that as deeply as it might have. The fact is that eliminating Plyler would threaten the continuance of public education. Why? Because kids out of school have a tendency to attract their peers to leave school as well. It will start with their siblings as a result of the phenomenon of mixed status families, where older children are undocumented, but younger children are birthright citizens. It will extend beyond the families to peers, and ultimately, it will be impossible to enforce truancy laws because any child who doesn't want to be in school will know to simply say, I'm undocumented, something that any truance officer would be unable to disprove.
Thank you, Mr. Saenz. I now recognize my friend from California, Mr. McClintock.
Thank you, Mr. Chairman. You know, a few weeks ago, the president put a very simple proposition to the Democrats. Do you believe that the first duty of the federal government is to defend American citizens and not illegal immigrants? Not one of our Democratic colleagues supported that proposition, not one. And we can plainly see that attitude on full display at this hearing, in fact, in any hearing where the subject presents itself. You know, I've never understood the logic of Plyler, which seems to be that illegal immigrants are both entitled to taxpayer-paid benefits, but at the same time are subject to deportation. That makes no sense. If they have no right to be here, I don't understand how they have a claim on taxpayer benefits. The other foundation of Plyler seems to be, well, don't worry about it, there aren't that many of them. Well, that might have been true in 1973. It's certainly not true today. It's indisputable that this is diverting billions of dollars of school funds away from educating American citizens and legal residents. In California alone, taxpayers are paying about $3 billion a year for this purpose. That's $3 billion of education funds that are not reaching American citizens and legal immigrants. Imagine the outrage from the Democrats if we proposed cutting $3 billion from California's public schools, but that's exactly what their open borders policies have done. Now, we just heard Ms. Scanlon tell us that this is good for students and good for taxpayers. I wonder if these people ever listen to themselves. And I think we're entitled to ask, how have our public schools fared since this, the largest illegal mass migration in history under the Democrats? Are students doing better or worse? Ms. Drogan, what does the data actually tell us?
Microphone.
So the data actually tells us when we're hearing numbers of a couple of thousand, that's completely inaccurate. Even if we're using a left-leaning pro-immigration organization that ranking member Scanlon quoted, FWD.US, they say that in Texas alone, there's at least 111,000 students. So this obviously is billions of dollars. We can look at the data and see since 2015 with the unaccompanied minors that have been released, if we use the TEA PEMS data that tells us how much we're spending, it's $18,125 per student across the state of Texas on average. Of course, doing English second language and whatnot costs more. But if we use that number, we can see that we're already approaching $2 billion at $1.78 billion. We could also use the Huffine Liberty Institute's research that went back over a course of 10 years to see the amount of money that we were spending in Texas, and they found that it's roughly 8% on illegal immigrant students. According to our data last year.
Somehow this is supposed to be helping our students. I don't understand that logic.
It's about $8 billion a year if we use their data. So
on my first trip to the border, I spoke with a Border Patrol officer who related a conversation he'd just had with the mother who'd taken her 8-year-old son on the dangerous trip to cross our border illegally. He asked her why she'd expose her child to such danger. And she answered, well, to get him a good education and get away from the gangs. And the Border Patrol agent said, well, don't you understand those gangs are already here? And your child will be placed in a classroom where he doesn't understand the language or the culture, and he'll look to those very gangs for his acceptance. You know, every day we hear of cases in which illegals with criminal records or gang affiliations are found in our public schools. There's a story in the news today coming out of Fairfax County, just a few miles from here, of a 19-year-old illegal alien from El Salvador who was groping young girls for months before the district took any disciplinary actions. Mr. O'Brien, have there been any studies of how many illegals with criminal records or criminal activities are in our schools today?
I don't believe so, only because it's virtually impossible to get the relevant data. We conducted studies that indicated that illegal aliens commit crimes at a rate anywhere from 2 to 3 times higher than citizens and lawful immigrants. So I would presume.
Yeah, there have been extensive studies presented to our immigration subcommittee on that very point. The Democrats love to claim, oh, there's no higher criminal rate among illegals. Well, that is completely belied by the facts. Mr. Rogers, what makes you think that the Supreme Court's inclined to reverse this decision?
Well, the Dobbs decision set out a very clear standard of 5 factors that can be used to evaluate whether prior precedent was wrongly decided and should be reevaluated. And like I said in my testimony, all 5 of those factors, Plyler fails all of them. And so I think applying the standard that they've set out, Plyler is ripe for a reconsideration.
Thank you.
Thank you, Mr. Chairman. Mr. Saenz, I want to return to something that the gentleman from California said. Did the Supreme Court say that a family could not be removed from the country if their non-citizen children were in a public school? Or are they still deportable if the family's not here lawfully?
So the way children tend to be deported, as I think you know, Congress member, is a parent is deported and has to make a decision whether to take the children with them or to leave them in the custody of someone else. That's the way deportation works for the Plyler class that we're talking about. But it's also important to note, in response to what the member from California said, the undocumented, many of them have a basis to remain in this country. And if they were actually placed in deportation proceedings, they will have defenses available to them, and many of them will, through that process, ultimately stay in the country permanently. So you can't say that all of
What would one of those be? You mean if they were seeking asylum, for example? Or?
No, if they were to seek some suspension of deportation because of long-standing ties in this country, because of continued connection in this country, or because they simply have a basis for adjusting relationship to someone else that they didn't have previously or didn't know provided a basis.
But my point is a little bit different, which is that there's nothing in Plyler versus Doe which gives anybody the right to stay in America if they don't already have such a right. You're positing that in some cases they might have such a right, but there's nothing in Plyler versus Doe that changes immigration law. So all the Supreme Court said in Plyler versus Doe was, as long as this family is in America, the children have a right to be in public school and should not be out on the street or kept at home or what have you. Am I reading that correctly?
That's absolutely correct. This is all about students who are here and therefore have to be somewhere during the day. They should be in public school.
But the Supreme Court never altered anybody's immigration status.
Not at all. Okay. Not at all.
So what's your response to Plyler's critics who are saying that this places a massive fiscal burden on the country?
So it's untrue, because you have to look at both sides of the ledger. And what we're talking about is an investment that we make in any child who's in public education. And that is, the payoff comes when they are able to participate in the workforce in many college education requiring professions and the like. A recent study points out that a large number of the recipients of services under Plyler end up in positions that require a college degree. Beyond that, you have to recognize that these are also taxpayers. These families are taxpayers like their neighbors. Their status does not change the fact that they pay sales taxes, property taxes if they have property, income taxes if there's an income tax.
But they're not in the Social Security system, right?
Exactly. They're not eligible, as you know, and as has been pointed out by others on this panel. So they are paying those taxes from what they are able to earn.
Yeah. So in ordinary times, if we're not in a time of anti-immigrant hysteria and nativism, people have accepted this for a half a century, right? And it has not seemed like a big deal that
I would argue, Congressmember, that it's not a big deal now for most of the people out in the public. There really are not huge numbers of bills moving forward in our legislatures. Yes, bills get introduced, but when legislators start doing their job and look at what the consequences are of actually attempting to implement a law like the one struck down in Plyler, they realize this is not wise public policy, and they tend to back away from it. So there's no clamoring to change Plyler versus Doe after 44 years.
Yeah. In the brief colloquy I had with the chairman at the beginning, we talked a little bit about my reference to the first great generation of revolutionary patriots, people like Tom Paine or Thomas Jefferson, as undocumented, or the descendants of undocumented people. I didn't think there was anything controversial about that. I suppose from the perspective of Native Americans who were here long before anybody else, everybody was undocumented at that point. But have we not had a fluid sense of the border? Now, we need to have actual laws that exist, but this has been part of the law that kids who are here get to go to school here, at least until their family is deported, right?
Absolutely. This is as well established as much of immigration law, because we didn't actually control our southern border until the middle of the 20th century.
Well, that was Mexico, right, until the 1840s and the 1850s, with the annexation, I think it was in 1845, of Texas and California a little bit after that. What is the bottom line then? Is all of this really headed to try to get a very right-leaning Supreme Court to overturn Plyler versus Doe? Is that what this is about?
I think that's the ultimate goal, but there is an impediment, which is this is now part of federal immigration policy.
Thank you. I yield back, Mr. Chairman.
I'll now recognize the gentleman from Kentucky.
Thank you, Mr. Chairman. I'd like to note that our annual debt has now gone past $39 trillion, and I yield my time to the chairman from Texas.
Well, I appreciate my friend from Kentucky, notably wearing his debt clock, where he's announcing to the world that we are now cracking $39 trillion. And I would note that there are a lot of reasons why, and this is one of them, among many, that we continue to have this fanciful notion that we can just say anybody can come into the United States and that it doesn't have an impact on our overall budget. And that the idea that it's like somehow, oh, there's this magic economic driver and economic creation of revenue that is offsetting the cost of our government services and programs and welfare and education and crime and hospitals, that somehow that magically pays for itself. It is absolutely insane. Mr. Saenz, there are approximately 2.4 billion children in the world under the age of 18. Can they all come to the United States and be educated?
Obviously not, but those who are here have a right now for 44
how about
years
a billion?
to an education.
Mr. Saenz, how about a billion? Can a billion children around the world come to the United States and get a free education?
Obviously not.
Okay, how about 500 million?
These are matters of capacity of
100
our country.
million?
It's a matter of the capacity of our country.
10 million.
Chair.
When we're a God-fearing, Jesus-loving people, 10 million people around the world can come here to the United States.
So far as I know, this country actually has religious pluralism and respects all religions, so I object to your question in that sense, but I'm not going to give you a number, Mr. Chair. The simple fact is
you're not going to give me a number, and you're not going to give me a number because you're not going to give me a number because you know this is fanciful unicorn nonsense.
I'm not going to give you the YouTube moment you're looking for because you're running for office.
You know this is unicorn nonsense. Well, you know what? This is an absolute aberration because you know precisely what's going on. You think that you can make policy via the court, that you can somehow establish that there's the right to come here to the United States and get a free education, but when posed with the question, how many people can come here, you know there's not an answer. Because right now, the people of Texas are the ones left holding the bag. Ms. Drogan.
That's false,
Ms.
Mr.
Drogan.
Chair. And you don't know me.
Ms. Drogan.
I'm not running for office.
It's my time and I'm the chairman. Whether or not I'm running for office is irrelevant.
Posed a question.
The fact of the matter is,
Mr.
Saenz, the fact of the matter is, Mr. Saenz,
and you
I'm the
accused me.
chairman of this committee, Mr. Saenz, and it's my time. And the fact of the matter is, the people of Texas, Ms. Drogan, are the ones left holding the bag.
Yes, sir.
Are the taxpayers in Texas paying education for illegal alien children to the detriment of American citizen children?
Yes, sir.
Can you expand on that? We talked about it before on the numbers. We've had over 100-something thousand unaccompanied alien children. How about the fact that we've got, for every English learner, Texas schools receive $616 or $950 for those enrolled in a dual language program. How much does that cost?
About $830 million, sir.
And how much money do we get from the federal government for that
$8.1 million.
So the Texas taxpayers are the ones left holding the bag on that number alone, correct?
Sir, 90% of it.
And what is the impact for the average school district out there that is dealing with the fact that you have illegal alien children that are being educated on the back of the taxpayers?
It's massive. That's what we were talking about, is this isn't just about the illegal children. It's also about the entire system. We have accountability systems. And these students, I pointed out several districts, Lake Worth ISD, 43.6% of them are English learners. This is a crushing barrier. It goes between 30 and 70% that are English learners in these districts that are slated for takeover. That doesn't just impact the students, the illegal students in the schools, it impacts the entire school and American citizens who are losing out on resources. Their teachers are being forced to try and do Google Translate on their phones. All of these things obviously impact the total education system, and the taxpayers are left holding the bag for it.
Somebody asserted earlier that there's nobody clamoring in the state of Texas to deal with this issue. First of all, do you believe that to be true?
That is 100% false.
Correct. And I hear about it all the time across the state of Texas, since I do crisscross the state of Texas quite a lot. And the reality is, with respect to that question, do we have the information or the data for the average American to understand the extent to which forced education of illegal alien children is having an impact on their kids, their school district, their bond issuances, their property taxes? Are we prohibited from having that information right now?
Yes, we are prohibited from having that information, and it has created a, quote, chilling effect on districts. I hear from teachers, superintendents, and leaders all across the state of Texas. They want this data collected so that we can have a comprehensive view of how this impacts students and taxpayers in our education system as a whole.
Thank you, Ms. Drogan. I'll now recognize Mr. Cohen.
Thank you, Mr. Chair. First, Mr. O'Brien, you made a comment that the statistics show that illegal immigrants or undocumented immigrants committed crime at a higher rate than other folks. I've had statistics, and we've talked about them as a committee, that are just the opposite, and they came from Texas. Where are your statistics from?
The statistics that we looked at were from the SCAP, which is the State Criminal Alien Apprehension Program.
The state?
It's a federal program that reimburses states for the cost of incarcerating anyone who is not a citizen who is present in the United States, particularly illegal aliens.
Do you have a copy of that study with you so I can take a look at it?
I don't have it with me. We can get you a copy of it.
Well, just to inform you, the Justice Department did a study a few years ago in Texas and said that undocumented immigrants are at a much lesser rate of committing offenses than other citizens. And other statistics show that as well. They are less likely to commit offenses. Most of them don't get out and are afraid right now to get out of their houses because they're afraid they'll get shot by ICE or taken to some detention camp and held for an unlimited amount of time, even if they have their little hats on and they're 5 years old, and they take them to Texas and put them away. That's not good for children. That's not good for America. That's not good for anybody. That's anti-American. So if you show me your statistics and get them to me, I'll look at them, and I'll send you the Justice Department statistics that show that illegal or undocumented immigrants do not commit crimes at a higher rate.
Well, we certainly can get that to you, and my experience as an immigration judge and a trial attorney with ICE would indicate differently. In my experience...
Your experience is not statistics. It's your experience. It's very subjective. I'd like to see objective.
I think the statistics are based on the experience of people like me.
Mr. Saenz, you were trying to say something in response to Mr. Roy, and he cut you off. You're not running for office. I understand that. Could you tell me what you were about to say?
I was going to say that, in fact, the number of students who are in school as a result of Plyler versus Doe is dictated by our immigration policies, in effect. So we can talk about the billions of people out in the world, but it has no reflection on what's happening in this country. As you earlier mentioned, we're talking about students who are here. As earlier was mentioned by your colleague, actually, we're talking about students who are here, their families are here, don't know how long they'll be here, but they're here, maybe here indefinitely or permanently. That's the class of students we're talking about who benefit from Plyler versus Doe. But not only they benefit, their classmates benefit, and all of society benefits because they then have the skills to ultimately contribute to our economy in important ways to the tune of billions, ultimately trillions of dollars.
I think Ms. Drogan was giving some testimony that undocumented or illegals have worse grades and are more likely to drop out and cause problems?
Well, the reality is
Excuse
that...
me, Ms. Drogan, I
Oh,
wasn't
thought
asking you a question.
I'm sorry.
That's not a problem. Mr. Saenz, do you remember her saying that?
So I think it's important to note that we don't have data about undocumented students and their grades. What we do know is that so many of those who were undocumented in elementary and secondary school do go on to higher education. These are the students who now have DACA and their younger colleagues who have been rendered ineligible for DACA. But these are the ones who are contributing to our economy who, frankly, through their contributions in healthcare and in other fields, saved us during the pandemic. So that's what we're talking about, not students who are low performing. I think it's important to note, because there's been a lot of conflation of this, that when you talk about English learners, you're not talking about undocumented students. The vast majority of non-citizens in this country are not undocumented. They have some other status, lawful permanent residents or other. And that comprises a portion of the English learner population. And frankly, a large portion of the English learner population is United States citizens born in this country who have every right to stay permanently and who are in school but come to school with a need to acquire English fluency at an academic level that they didn't acquire in their homes prior to coming to school. Similarly, the chair mentioned in his opening remarks the Latino population of a particular school district. Latino does not equal undocumented, not by any means. The Latino population is overwhelmingly US citizen and lawful permanent resident in this country. So talking about increased numbers of Latino students in a school is completely irrelevant to what we are talking about here, which is the experience of undocumented students in public schools.
Thank you, and I yield back the balance of my time.
I'll recognize the ranking member for some UCs.
Thank you. I ask unanimous consent to enter into the record a March 18, 2026 statement and report titled "The Power of Plyler," highlighting how the Plyler decision has aided in decades of economic advancement. And
Without objection.
I would also introduce the Texas-specific data showing the net fiscal impact of Plyler has been $93 billion to the positive
Without
in
objection.
Texas. And finally, I would enter a 2021 study by the National Bureau of Economic Research entitled "Presence of Immigrant Students Boosts Test Scores for All."
Without objection. I'll now recognize the gentlelady from Wyoming for 5 minutes.
Thank you. When discussing the issue of K-12 education, there is no free public education. Every decision that is made here in Washington, D.C., or within any state or local community comes at the cost of the American taxpayer. Plyler versus Doe effectively imposed an unfunded mandate whose consequences due to years of neglect and mismanagement of our immigration system across multiple administrations has gone far beyond what could have ever been foreseen in 1982. This is evident as the court's decision rested on the assertion that the number of illegal aliens in public schools was small and that there was no evidence in the record suggesting that illegal entrants impose any significant burden on the state's economy. We know that is absolutely untrue. And I'm sure that Mr. Saenz, if he'd actually read the data, would recognize that as well. This decision, which came at a time markedly different than the circumstances we face today, negatively impacts every aspect and participation of our public education system at the cost of hardworking American families. Reporting from 2023 found that New York City grappled with the challenge of incorporating nearly 20,000 illegal alien students into its classes, while in 2024, the Denver Public Schools incorporated over 3,000. Ms. Drogan, knowing that schools are generally unable to ask about a student's immigration status, does any consistently reliable data exist that could give us an idea of how many illegal alien students are enrolled in our public school systems and how much it costs the American taxpayer?
It's all just estimates, and I would say that that's very intentional, whether it's weaponized opaqueness or incompetence. The idea is that they don't want us to identify them, to understand and be able to give accurate numbers on how many, where they are, what the impact, not just the cost, but the socioeconomic impact of entire communities. Again, I was listening to Mr. McClintock talk about a mother talking about she wanted to get her kids away from gangs. There are gangs in Houston schools. Trende Aragua is in his Houston schools. This has been proven. So to say that we can give an accurate number. We can use Census Bureau data, we can use different entities that try and extrapolate from Customs and Immigration or other services, but the truth is we don't know, and that is very intentional, particularly by the Obama administration's Dear Colleague letter in 2011.
Well, then, Mr. O'Brien, wouldn't you say that the same is true for crime statistics? Isn't that intentional to ignore the immigration status of many people who commit crimes in order to cover up the fact that, in fact, illegal aliens do commit crimes at a higher rate than native-born?
Yes, that is 100% correct. And you also have to take into account that any illegal alien is by definition a criminal because they have violated 8 U.S.C. 1325, improper entry by an alien, and so they've committed a crime to enter the United States.
Okay. If the data is not there and verification is not an option, are there adequate safeguards at the state and local level to monitor and mitigate misuse of taxpayer funding, including issues such as residency or enrollment fraud?
No, not anyone that can track it accurately. We simply do not have the data.
What reforms, if any, have been taken at the state and local levels, particularly over the course of the Biden-Harris border crisis? Has there been any?
No, the most recent has been Tennessee has passed a law through the House asking to be able to track this data.
All right, and again, Ms. Drogan, given that the national average cost of educating a single student exceeds $16,000, how have state and local governments accounted for spikes in enrollment stemming from unchecked illegal immigration?
It's crushing. The debt in Texas is growing from not just what we're spending at the state level, but we also have to recognize that our bond debt, we have $234.2 billion of bond debt. This brings massive amount of debt from our taxpayers, and we cannot identify who they are, where they are going, and the impact on Texans as a whole.
So have essential services programs or facility improvements been reduced or delayed due to the enrollment burden that Plyler versus Doe imposes on our nation's schools?
I think that's a very accurate statement that there are students that are not getting the services, American students, whether they're special education students or in other classifications that are not getting the services because we are having to redirect student funding to pay for English second language teachers, tutors, all sorts of this. But also, as I noted in my testimony, there's a whole host of other problems, not just chronic absenteeism, but you look at the medical results, the mental health problems. When you have these students that are coming in and they have severe mental health problems due to traumatic events, whether it's rape or violence that they've occurred, this takes other resources out of the school system.
Okay, well, I thank you for the testimony. I have many other questions, but I also want to, at this point, ask unanimous consent to introduce an article entitled Illegal Immigrant Student Accused of Groping Girls in North Virginia High School, related to an adult student who lied about his age so that he could enroll in high school. I also would like to
Objection.
Unanimous consent for an article, Vance reveals $19 billion in fraud uncovered in Minneapolis and hints that California is the next target,
Without objection.
clearly erasing any financial benefits that illegals may provide in this country. Thank you, and I yield back.
I thank the gentlelady from Wyoming. I will now recognize the gentlelady from Washington.
Thank you, Mr. Chairman. I wanted to start just by saying there are no illegal children. I think it's a very cruel thing to say about children. There is an illegal war on Iran happening right now that's already cost taxpayers $16 billion. There is an illegal cover-up of the Epstein files that is happening right now. There is an illegal corruption by the Trump administration officials like Kristi Noem in directing government contracts to family members. Those are all illegal. But it's important that we don't say that there are illegal children. That is a very cruel and hurtful statement to make. Republicans would have the American people blame immigrants for all their problems, but it's not immigrants who are making it harder to feed families. Republicans did that by cutting hundreds of billions of dollars from the Supplemental Nutrition Assistance Program. It's not immigrants who are raising the cost of health care for children. Republicans did that by cutting hundreds of billions of dollars from the Children's Health Insurance Program. And it's not immigrants who are hurting the quality of our public education. Republicans are now trying to do that by overturning the Supreme Court's historic decision in Plyler v. Doe. That decision established that undocumented students are protected by the 14th Amendment against discriminatory state laws that deny them equal access to public education. And Justice William Brennan said it best when he said, these students, quote, live within the structure of our civic institutions and contribute to the progress of our nation. Mr. Saenz, a lot of these discussions end up dehumanizing immigrants, and I wanted you to humanize these students for us. Who are they? Bring them into the room with us. Tell them who they are, how they've contributed to the progress of our nation.
Well, first of all, they're the older brothers and sisters of U.S. citizens. And then when they complete their education, go on to higher education, and adjust their status and remain here permanently, they are the U.S. citizen fathers and mothers of United States citizens today. When you talk about a decision that goes back 44 years, we have a long history of folks who were able to attend school because of Plyler, because they were in Texas or another state that might have adopted that policy, and who have succeeded beyond anyone's dreams, making contributions to our economy, to our society, and even to government.
And you mentioned during COVID, I want to bring another example from my home state. Itzel Santiago Pastrana grew up going to public schools near Seattle, where she had teachers who mentored her and inspired her to attend the University of Washington. As a DACA recipient, now a naturalized U.S. citizen, you talked about this progression in some of your answers, she has decided to give back to her community by working at an immigration law firm for a decade and at the State Attorney General's Civil Rights Division. And the whole discussion reminds me of the debate that we keep having in this committee around birthright citizenship, another clear protection of the 14th Amendment that Republicans continue to attack. This subcommittee held a hearing last year, and one of the witnesses testified that eliminating birthright citizenship would, quote, create a permanent underclass, a caste system which was the very result that the Reconstruction Congress intended to end, end quote. Mr. Saenz, would removing students like Itzel from the classroom also create a permanent underclass?
It would, and the majority in Plyler versus Doe recognize that, and creating such a permanent underclass would have immediate negative repercussions for the public school system. As I was outlining, you will lose students in the schools, not just undocumented students, and it has long-term consequences, of course, for all of society. When you have a permanent underclass, they are deprived of any ability to contribute in the way that DACA recipients and others have continued to contribute as doctors, as lawyers, in important professions and positions throughout society.
What about the impact on U.S. citizen children? What's the impact in the classroom likely to be?
It actually improves their education because they're exposed to other cultures, they're exposed to other experiences.
When those undocumented
when those students
are
are sitting next to them.
And when they're not there,
They
the opposite is
lose
true.
all of that. They lose all of that. Their only encounters with those students would be out on the streets. That's not likely to be a very positive encounter on either side. We're talking about enhancing public education by continuing to follow a 44-year-old decision or bringing public education to an end as we know it.
In addition to taking away benefits in the classroom, what are the broader consequences to the American economy? You've sort of referred to this. If Plyler was overturned and students like Itzel were denied equal access to education?
Well, our economy would take a huge hit. I mean, there's no denying that people who are allowed to have an education are able to contribute more to our society through tax payments and through their contributions on the job. If you take away even the basic education that folks need, their ability to contribute will be rendered almost a nullity.
I think this is such an important conversation that you're bringing to the table. I thank you. Mr. Chairman, I yield back, but I do have some unanimous consent requests to enter. First one is granting, this is from New America, granting undocumented students access to public education delivers $633 billion return on investment.
Without objection.
Next one is from Brookings. Are immigrant students disproportionately consuming educational resources? And I would just say that the conclusion is absolutely not.
Without objection.
Next one is from NPR. Immigrants are less likely to commit crimes than U.S.-born Americans, studies find.
Without objection.
Next one is from Cato Institute with similar conclusions, illegal immigration and crime in Texas.
Without objection.
And the last one is from the National Institute of Justice, entitled Undocumented Immigrant Offending Rate Lower Than U.S.-Born Citizen Rate.
Without objection, I thank the gentlelady from Washington. I'll now recognize the gentleman from North Carolina for 5 minutes.
Thank you, Mr. Chairman, and thanks to all of you on the panel today. Let me jump into this. Mr. Rogers, you touched on something, I think, when Representative McClintock was speaking, and you had mentioned in your written testimony that caught my attention that the 2022 Dobbs decision at the Supreme Court set the framework for overturning Plyler versus Doe, and I just want to give you a few moments to kind of dive a little deeper into that and explain why you believe this to be the case.
Sure, thank you. The Dobbs decision set up 5 standards for whether a prior precedent should be overruled. The first one was whether the nature of the court's error, and if it's an egregious error, that weighs in favor of overruling. As I talked about, the court applied the wrong standards for the Equal Protection Clause. The second is the quality of the reasoning, and if you actually read the decision, it's very bare. It just basically says this is good policy. It doesn't give actual legal reasoning. The third is workability. It's whether it's a standard that can be applied by courts, and the standard the court invented, no one's been able to define or understand what it means. The fourth is its effect on other areas of law, and as we've heard, this decision has affected how states can implement their own education policy. We heard some testimony about how states haven't adopted Plyler-type laws like the one that issued in Texas because it's good policy. If it were good policy, then we wouldn't hear people concerned about Plyler being overruled. But the fact that they're so concerned means they know that states would adopt it if they didn't have this restriction. And then the last is reliance interest, whether companies or whether individuals have financial reliance interests on the rule. And there's no financial interest of the type of like contract interest here. So all 5 weigh against Plyler being upheld.
Excellent. Thank you, sir. And Mr. O'Brien, can you explain how the Supreme Court in Plyler acted like the legislative branch rather than the judicial branch?
Sure. The function of a court is to apply the law as written. In this particular case, there really was no constitutional issue before the court based on the court's own reasoning. The court found that illegal aliens was not a suspect class. The court also found that a free public education is not a fundamental right. Therefore, it's arguable that there was no constitutional issue whatsoever in front of the court because, by definition, if illegal aliens is not a suspect class, then the state of Texas was not discriminating against anyone. But for whatever reason, the Supreme Court granted writ of certiorari and went forward with it, and then they completely ignored the relevant standards and they ruled entirely on policy grounds. Now, the consideration of policy under our constitutional framework belongs to the Congress of the United States. It does not belong to the courts. The courts apply the law based on canons of statutory construction and other legal principles. But policy calls belong to Congress.
So you would say the court should not be able to require free education for the children of illegal immigrants?
No, not by any stretch of the imagination. That is a decision that if Congress wished to make, it probably could have, but it in no way fell within the purview of the court.
Thank you, sir. And Mr. Rogers, coming back, as I understand, the Plyler versus Doe, the state of Texas argued the illegal alien children imposed a burden on the state's education system. The court, in a decision, rejected such a claim. And here we are 40 years later, where there's a lot more data to underscore that point. Can you explain the burden that the massive influx of illegal aliens places on the state's public education systems?
As we've heard, they impose a tremendous burden because most of them arrive not speaking English. They require special services, which means that American citizen children can't get those services because there's limited resources. An interesting example of the policy decision about this is if a temporary immigrant arrives with a tourist visa, they're actually required to pay tuition. Under federal law right now, they have to pay tuition for their kids, yet illegal aliens who are also here temporarily don't have to, which is tremendously unfair that they're treated differently and given special privileges. Thank you, sir. Mr. Chairman, I yield my time.
I thank the gentleman from North Carolina. Mr. Rogers, in your last 30 seconds here, it is your considered judgment that there are states right now taking actions to start pass laws to say that they should not have to fund education for illegal alien children, and that this should move its way through the courts, and that the court should take it up. Is that correct?
Correct.
Thanks, Mr. Rogers. I will now recognize the gentlelady from Vermont for 5 minutes.
Thank you, Mr. Chair. I'm a former middle school teacher, which I always say is perfect preparation for this place. I know the incredible value and importance of public education, and to say that the children of immigrants are not entitled to learn and to grow in public schools is an extreme position. We're talking about children. This is a fundamental question of decency and who we claim to be as an Americans. I want to echo the comments of my colleague, Ms. Jayapal, who said there are no illegal children and we should not be referring to them in this way. And how has this administration treated children and families so far? Well, it has cut early childhood education. It has cut children's health care. It has cut child nutrition programs. It has cut infant formula inspection. It has cut research for vaccines. They even eliminated funding for children's television programs on PBS. This is not an administration that is looking out for children and families. As I said, I'm a former teacher and I'm a parent, and I know how hard it is being a kid and a teen in this country today. Our kids carry the real fear of gun violence in their schools. They carry the real anxiety of unaddressed climate change. They have to navigate social media landscapes that exacerbate the crisis of loneliness and disconnection. And for the children of immigrants, they have to deal with all this on top of the fear that they're experiencing right now as there are targeted raids happening in communities across this country. And just last week in Vermont, masked agents decided to create chaos and a dangerous situation near 2 schools. And I heard from parents about how frightened they were to drop their kids off at school and to pick them up at the end of the day. The actions cause fear and concern among this community in Vermont, and that kind of anxiety is going to live with those children and these families for a lifetime. Mr. Saenz, can you describe the level of fear and anxiety affecting immigrant communities in the U.S. today?
It's extreme, and it's extreme because of what you have described, but it starts with the undifferentiated immigration enforcement that is happening across the country, targeted at certain states, but across the country, and accomplished through masked agents who do not wear identification that they're law enforcement at all. This is not what kids have been taught should occur in this country. So it occasions great anxiety, and studies have begun to document higher degrees of absenteeism because of it. But you add to it the challenges that you've also outlined. When you take away adequate nutrition, you take away adequate health care, you take away adequate housing, then those are the things that kids have anxiety about. Is my family gonna have a place to stay tomorrow night? Am I gonna get a meal tonight? Am I gonna get the health care that I need? On top of that, if they actually have a healthcare need that they're not getting, they'll be absent from school. But all the kids who are in school are preoccupied by that kind of consideration, and it leads to their inability to concentrate, as I'm sure you saw many times for all kinds of reasons in middle school, but this just adds to it, and it makes them ill-equipped to really take advantage of the education while they're sitting in the classroom. So all of it accumulates.
And I want to make sure I highlight something here. It's not just immigrant children. It is any family that is a family of color in this administration, because we have seen that ICE enforcement is concentrating on people who have a different color of the skin and a different accent. They have widened the search. It's creating lots of harm in our communities. And so when you think about a child's immigrant status, and that if it can be used as a means to deny immigrant children of an education, where does this end? What is the logical conclusion for this in terms of equal access to public education? Where will it end? What other groups will be excluded from this?
Well, you have to assume that the theory that there's no rational basis that would strike down the Texas law means that there is no rational basis standard to strike down excluding disabled kids from school. They're also expensive. Their education is more expensive. So you can imagine that they would be the next target. And beyond that, you can single out any group of students because education is not a fundamental right. And under the theory being put forward today, there would be no basis to challenge any decision on equal protection grounds that would exclude any group of students. So you can imagine a society split between those who are allowed to receive a free public education and a large and growing group that are denied that opportunity.
I agree with you, and I stand with students, I stand with their families, I stand against the fear that is being created. And if we want a better world, which I think we all do, I think we can come together on that on this committee, then we have to support and protect young people in this country, not attack them. Thank you so much, and I yield back.
Thank the gentlelady from Vermont. Before I recognize my friend from Texas, I have a couple unanimous consent requests. Ask unanimous consent to put in the record an article by FAIR demonstrating that data showing illegal aliens have higher crime rates without objection. A CIS report showing misuse of Texas data understates illegal immigrant criminality without objection. I would also put in a report by FAIR showing that there were approximately, respectfully, 16,000 illegal aliens in Vermont compared to 2.7 million illegal aliens in the state of Texas, in a report demonstrating state-by-state data. And with that, I would recognize my friend from Texas, Mr. Gill.
Thank you, Mr. Chairman, and thank you for holding this hearing and for fighting so hard against destructive mass migration. And thank you for the witnesses for taking the time to be here. Mr. Saenz, if somebody crosses the border illegally, what should happen to them?
Federal law indicates that there are steps that can be taken to remove them. Now, that can happen at the border,
So they should
or
be
it can
deported.
happen when they are integrated into society. There are protections once you're integrated into society, especially
But
depending
if
on
they're
how long.
if we find them crossing into the country illegally, they should be deported. To put it simply, is that right?
If someone does not have a right to enter, yes, there is a right under federal law to interdict them and prevent them from entering.
Right.
That's been a basic element of immigration law for a very long time.
I agree.
Including during Plyler.
I agree. Do you believe that American tax dollars should be used to rehabilitate criminal and illegal aliens within our own borders?
I believe it's in our own interest to rehabilitate anybody who commits a crime.
Including criminal and illegal aliens
If it
who
happens
never should
within
have
our
been
borders, if it happens within our borders, it's to the benefit of all of us to rehabilitate them. Rehabilitation of those who are convicted of criminals is not for their own benefit. It's for the benefit of society.
How many criminal and illegal aliens should we rehabilitate?
Again, anyone who commits a crime and is convicted of a crime should be rehabilitated
there's no
for the
limit.
benefit of the entire
So an illegal alien
society.
comes into our country, murders or rapes somebody, we ought to rehabilitate them, is your view. And there's no limit to the number of illegal alien criminals we should rehabilitate? Is that your testimony?
I wasn't asked to testify about that, Congressman. I asked to testify
I'm
about
just clarifying
Plyler.
your
Not sure
your
what
position.
this has to do with
I'm clarifying
Plyler.
your position, which you just attempted
I think
to lay
my
out.
position is quite clear. Thank you.
Okay, how much money should we spend on rehabilitating criminal and illegal aliens?
We should spend as much money as necessary to rehabilitate anyone who is convicted of crime in this country. Again,
As much
this
now-
let me just note, Congressman, it has nothing to do with Plyler versus Doe.
No, we're
These are
getting
children. These
We're
are
getting
children,
there.
and with
We
an
should-
education,
should we-
they are far
Sir, we're-
less
we're
likely
getting there, and you're
to
here to
ever
answer my
commit a crime.
questions, actually. Couldn't we just secure the border and deport illegal aliens as opposed to rehabilitating them on our own tax dollars?
So that's too facile, Congressmember, and I think you should understand that. The simple fact is society benefits from rehabilitation. It's not a gift to anyone who's convicted
Society's
of a crime.
paying
It's
for
society.
rehabilitation, it sounds like. Do you believe that there should be a strict wall of separation between local law enforcement and immigration officials?
Do I believe there should be such a law? Yes, I do.
That there should be a strict wall, to be clear? A strict wall of separation between
All
local
laws,
law
all
enforcement.
laws are strict. I'm not aware of Congress or any legislature passing a lenient law.
It's wall,
versus a strict law.
W-A-L-L.
So
A strict
law.
wall, W-A-L-L.
A wall. I'm
Yes,
sorry, I
sir.
thought you said law.
No.
I apologize.
A strict
no,
wall of separation
I
between
think a
local
wall
law.
would be incredibly ridiculous, frankly.
A wall of separation between local law enforcement and immigration
Oh,
officials.
a wall of separation. Okay. Yes, Congressmember, yes. Again, I do believe there should be a law of separation. And if you want to describe that law metaphorically
saying that
as a wall,
Okay.
I would accept that.
Okay, I was actually using your words where you said there should be a strict wall of no cooperation between local law enforcement and federal immigration authorities. That's something that you had said in an interview with NPR in November of 2016. So if police
So
arrest...
I've just acknowledged that.
Right.
So
So if
not
police
sure why
arrest
you're
and-
putting myself to myself. I'm sure that
I'm asking
interview
you,
was not about
I'm the one
Plyler.
asking questions here, not you. If police arrest an illegal alien for breaking into somebody's home in the middle of the night, should they turn that illegal alien over to immigration officials?
So Plyler versus Doe guarantees an education.
just a yes
and
or no
as a
question.
result, that means that those kids who receive that
take the-
education are
You
far
don't
less
think
likely
that
to break
if some-
into anyone's home, Congressman.
But I'm asking, let's say they do. Should they be turned over to immigration officials? It's just a yes or no question.
No, they should be put through the criminal law system that we have.
What about after serving, let's say they're convicted and they serve a sentence, and this is a criminal and legal alien, they broke into somebody's home, they're convicted, they serve let's say a 5-year sentence. Instead of releasing them onto the street, should local law enforcement or prison officials give them over to immigration officials?
There are too many repercussions of a policy like that. You're putting it in the context of a single instance.
No, it's
very difficult.
It's very clear that your answer is no.
No, that's not clear, sir. That's not clear, sir. Please don't put words in my mouth. You have my words from NPR, and what I say here, you don't need to put words in my mouth.
Should American taxpayers pay for Medicaid for illegal aliens?
In many circumstances, yes.
They should.
Not just American taxpayers, but immigrant taxpayers who also pay taxes as well.
For Social
As you know,
Security
sir, there is no
aliens?
exception for tax paying based on immigration status.
I'm the one who's asking questions here. Should American taxpayers pay for Social Security for illegal aliens? It's a yes or no question. I think the answer is no.
It's not a yes or no question. It doesn't happen. We don't provide Social Security benefits to undocumented people. I wasn't aware that was a topic of today's hearing.
I don't think that should happen, and I'm asking you if you think it should happen.
This is the last question. The witness may answer the question.
I don't believe that that's a question when it doesn't happen. It's misleading to suggest it does. No one who's undocumented
It's a really basic question,
Social
and you don't want to
Security.
answer it because you've got a crazy radical open borders agenda that we can all see. Thank you, Mr. Chair.
I thank the gentleman from Texas for his questions, and I'll now recognize the ranking member for UC requests.
Yes, thank you. I ask unanimous consent to enter into the record an article written by Alexandra Villarreal, published by The Guardian, January 23rd, 26. There are kids not going to school. Fear of ICE is keeping children from classes in Connecticut.
Without objection.
Also ask unanimous consent to enter in the record an article written by Bree Hatch and published by Chalkbeat, Tennessee on October 28th, 2025, titled, "In Increasingly Hispanic Memphis Schools, Immigration Enforcement Surge Brings Fear and Absence."
Without objection.
Ask unanimous consent to enter in the record an article written by Kate Payne, Bianca Vasquez Tonis, and Gisela Salmon, published by NBC News, November 17, 2025, entitled "Immigrant Student Enrollment is Dwindling at Schools Across the U.S. Amid Immigration."
Without objection.
Ask unanimous consent to enter into the record an article written by Justine McDaniel and Maria Louisa Paul, published by The Washington Post, November 24, 2025, titled "In Cities Targeted by ICE, Empty Desks and Disruptions
Without objection.
Follow." CQC to enter into the record an article written by Daniela Silva and Natasha Korecki, published by NBC News on October 14, 2025, entitled "Chicago Teachers Say Immigration Enforcement Near Schools is Scaring Kids
Without
and
objection.
Disrupting Class." Finally, I ask unanimous consent to enter in the record an article written by Mara Klecker and Anthony Lonetree, published by the Minnesota Star Tribune, January 15, 2026, titled "Attendance Drops at Minnesota Schools as Federal Immigration Enforcement Intensified."
Without objection.
Thank you.
I'll now recognize the gentlelady from California.
Thank you, Mr. Chair. You know, I just have to say that many of us travel around the world. And in my travels, I remain in awe at how educated so many children are in other countries. They are bilingual, they are trilingual, they are culturally proficient and aware. It is amazing. And it is so disturbing that it seems like my Republican colleagues in this committee are interested in A, dehumanizing other children, and B, advocating for our children to be unprepared for this world. At one point, you know, the languages that folks were hearing in the schools were Welsh, Irish, Polish, German, Italian. And now we want to shift that to children of color as we continue to find ways to isolate ourselves and to humanize children. So, Mr. Saenz, folks do like to talk about the money, so let's get into the money. There was a FWD report called The Power of Plyler that estimates that adult Californians who benefited from Plyler have contributed $655 billion in combined past and future GDP over their lifetime. So can you quickly walk the committee through what that number looks like on the ground?
What it means is we have contributing members of our society who are doctors, who are teachers. Many formerly undocumented students end up in the education profession, in the healthcare profession. They are making contributions in business, in some cases in C-suite positions. It means that we have the opportunity to translate that investment in education into the GDP that report you cited talks about.
Right, and the report actually shows a net fiscal gain of $145 billion in California alone. So that's income tax revenue over lifetimes minus the cost of educating those children. So for those who claim we can't afford Plyler, how do you respond to the argument that we actually can't afford to lose it?
I think it's absolutely clear because we'll have immediate repercussions in our public schools, really seeing a further diminution in their ability to deliver an education to anyone. But in the long term, we'll lose all of that additional revenue and economic contributions and the things that you can't even quantify in money. The innovations, the inventions, the new ideas, the inspired leadership provided by formerly undocumented immigrants in our society.
And sort of like connectivity to humanity. So if Plyler is overturned, California stands to lose $99 billion in future economic output just from children currently in school in 2023. What does that trajectory look like nationally in your professional assessment?
Well, you can extend it out further because if Plyler is overturned, a number of states will begin to attempt to deny an education to kids. I ultimately think they would reverse as they see their public schools fall apart because of the exclusion of a certain class of students. But over time, you're talking about trillions of contributions to the economy, including to revenue from a population that is permanently going to be in this country. So the contrast is a permanent underclass incapable of providing any kind of serious contribution to either tax revenues, the economy, or to the many other elements of social connection that we've talked about.
Thank you. And to Mr. O'Brien, your organization advocates for restricting Plyler, but the record here shows that the core argument you make, that educating these children is a cost to taxpayers, simply doesn't hold up. The data shows tax revenue from undocumented workers alone covers the cost of educating these children more than 9 times over. So am I correct in saying that you believe that the hundreds of billions of dollars in economic contributions from Plyler beneficiaries, including over $600 billion in California alone, were not worth the investment?
I don't believe that those contributions were made. I believe that the data upon which those claims are based is erroneous and that there is a cost imposed by Plyler.
Okay, so you don't like the data when it doesn't say what you want it to say. So I'm going to stay with the numbers in the report and the numbers that are here. FAIR has argued that educating undocumented children is a cost to taxpayers. The data in front of us shows a net fiscal gain of $145 billion in California, $43 billion in New York, $20 billion in Arizona, $93 billion in Texas, $42 billion in Florida, $21 billion in Washington. So I think, once again, we should be talking about why we cannot afford to lose Plyler, not why it is so important to lose all of these economic gains. And Mr. Chair, I just want to enter into the record, I'd like to ask unanimous consent to enter into the record the report, forward.us report, The Power of Plyler.
Without objection.
Thank you so much, and I yield back.
Thanks, gentlemen from California, and I will now recognize the chairman of the committee, Mr. Jordan.
Thank you, Mr. Chair. Mr. Rogers, what percentage, any idea what percentage of the United States population lives in a sanctuary jurisdiction?
That's a good question. I don't have that numbers, but it's far too high. It should be 0.
Yeah, it should be 0, but it's like 31.5%. 18 cities, 11 states, 3 counties, and the District of Columbia. And because these are big blue cities, big blue states, again, almost a third of the population lives in a jurisdiction where, and correct me if I'm wrong, but where local left-wing political leaders tell local law enforcement not to work with federal law enforcement when it comes to enforcing federal law. Is that your understanding of sanctuary jurisdiction?
Correct, yeah.
And is that literally one of the dumbest things you've ever heard?
Yes, and it's against federal law as well because it's a
No
crime to
kidding.
shield
But
aliens.
in a third of the country, that goes on. And last year alone, we just marked this bill up 2 weeks ago. Last year alone, 2025, 17,864 times, ICE would file a detainer with a local jail, local detention center, where there's a person who's in the country illegally and been charged with a crime, and ICE would send a detainer notice saying, hey, if you're gonna let this guy out, give us a call. And 17,864 times in 2025, local law enforcement, because left-wing politicians told them to, would not work with federal law enforcement and many times release these people to the streets. Again, I'd ask you, is that a crazy policy or what?
It's absolutely crazy, and it's totally counterproductive for everybody, illegal immigrants and legal immigrants who live in those communities.
And would you be surprised to learn that several of those people who were released then went out and caused harm, did some crime against some other American, or maybe some other migrant, who knows, but committed some crime after they've been released when they could have been turned over to federal law enforcement?
It's not surprising, it's totally predictable, and it's a tragedy for each of those people.
Totally predictable. Mr. Saenz, would you say that's a good policy or a bad policy?
Which policy?
Policy,
Congressman?
sanctuary jurisdiction.
It's a good policy.
It's a good policy to let 17,000 people out, potentially 17,000 people not on a detainer, and let some of those people released to the streets who had already been charged with the crime, and then they commit another crime, and you're saying that's a good policy?
That's your characterization of
No,
how that
that's the
works out.
facts.
It's an inaccurate
That is the
characterization.
facts.
No, I'm sorry, it's inaccurate.
Well, okay, so tell me what's
If you
inaccurate.
wanna have accurate-
31% of the population lives in the sanctuary jurisdiction. Is that inaccurate?
I don't know. I'll take your word on that. I
Okay.
don't know.
So that's not inaccurate. What about this? 17,864 times a detainer was not honored last year by local law enforcement when ICE issued a detainer.
Again, I have no idea, Congressman. I came here to talk about Plyler versus Doe, and I can absolutely guarantee you there has never been a detainer issued against a student enrolled in public education as a result of Plyler.
I'll get to the student
But the
issue.
hearing is about Plyler. So I don't have an answer to your question about whether the data you have is accurate related to something completely unrelated.
Well, suspend. It is the gentleman's time to ask the questions. The witness can respond to the questions, but we're not going to talk over each other.
Mr.
Chairman.
O'Brien, to get to Plyler, there's a cost associated with this, right? With this
Yes,
decision.
there is.
Significant. I mean, I think the court said way back in 1982, the number of illegal aliens in public schools was small, and there was, quote, no evidence in record suggesting that illegal entrants impose any significant burden on the state's economy. That was the ruling back in 82, but things have changed a little bit since then, haven't they?
They've changed drastically, and the estimated combined cost to the taxpayers, federal, state, and local, is somewhere in the neighborhood of $80 billion with a B.
And it was particularly exacerbated the previous 4 years in the last administration. Is that accurate?
Yes, by a significant margin.
8 to 10 million people coming into the country in a 4-year time frame. Many of those were students. I remember the Biden administration lost track of hundreds of thousands of those students. Is that right?
About 300,000, that's correct.
Yeah. So there's certainly a cost associated with that. That's what this hearing's about as well. Yeah. Let me ask one other question here, and then maybe I'll yield a few seconds to my good friend from Texas. Is Thomas Paine an undocumented immigrant or a founding father, Mr. Rogers? I'm just curious.
He's a founding father, and he's not an undocumented immigrant.
Yeah. What, Mr. O'Brien?
He was a citizen of the UK who went to another territory of the UK, so it was like moving from Massachusetts to New Hampshire.
Yeah, yeah. Ms. Drogan, I just was curious if you thought he was an undocumented immigrant or a founding father.
He's a founding father.
And what about you, Mr. Saenz? What are you going to say to that question?
I'd say the terms don't apply back when Tom Paine was alive. So it is true, he was undocumented. But that really wasn't a category of any concern.
Was he a founding
in the 18th
father?
Century. He's both.
Come on,
founding father.
Come on, it's common sense, pun intended. Was he a founding father?
Of course he was.
All right. God bless you. I will yield. Well, sorry, Mr. Gill, I ran out of time.
I appreciate it. The chairman, I will now recognize the ranking member for UC request.
Mr. Chairman, don't leave yet. I have a question for you. If you
Mr. Gold, hold on. I'm going to recognize the ranking member for UC.
I can hold the UC.
And Mr. Goldman, I do have to do an interview. I was like, I do.
You know,
Make it quick.
I have one question for you.
Yes, let's hear it.
Of the 17,000 and however many.
864.
Yep. How many of those people had a criminal conviction and completed their sentence?
I don't know that number. I know there was a detainer filed, at the local detention center or jail, and it was not honored. And some of those individuals were released, and we know some of them committed crimes.
Right, and the problem, you can go, that's fine, but the problem with you constantly making this argument about sanctuary cities is that these are charged defendants. And as President Trump knows very well, we live in a country that has due process, where you are innocent until proven guilty. And if the grounds for which an individual is to be deported is based on that criminal charge, we do not deport people based on charges. We deport people based on convictions. And so if you want to talk about the sanctuary laws, let's talk about what the issues that you are raising are. And Mr. Rogers, Mr. Jordan asked you whether or not the sanctuary laws prohibit state or local law enforcement from cooperating with federal law enforcement. The problem is these are criminal law enforcement agencies on the state and local level, and immigration is civil law enforcement. So we can imagine a scenario, of course, where the civil immigration enforcement completely overwhelms all of the resources of the local police and the local criminal law enforcement. That is the reason why sanctuary city laws apply, is that so the police can actually focus on crime, not on federal civil immigration. But as Mr. Saenz says, we are here to talk about children. Children that this administration continues to attack. This administration has increased the fees for any unaccompanied child to actually apply for a visa. Where is that unaccompanied child supposed to get money from? This administration has canceled contracts for legal representation for children. This administration has consistently, and my Republicans have consistently attacked children who may be transgender and affect no one else. This administration is waging a war on children. Leave children alone. And the bigger point is what you haven't touched on is all the expenses that these undocumented children take up in their public education. Well, Mr. McClintock says they're benefiting from taxpayer benefits. Well, guess what? Undocumented immigrants are taxpayers. In fact, the amount of money that we get from taxes paid by undocumented immigrants is 9 times as much money as is paid on their education. And in fact, studies show that $633 billion in local and state tax revenues exceed whatever the education costs are. It increases our GDP by nearly $3 trillion. Why don't we stop terrorizing immigrant communities, shooting Americans, ripping Americans out of cars, arresting people at courthouses who are trying to lawfully apply for asylum? Why don't we have a bill and a hearing on that, rather than continue to attack children who are brought here without any ability to make the decision themselves, and yet you want them to what? Stay home, sit at home when their parents decide to come here? Rather than get an education, contribute to our society, which the overwhelming majority do. Yes, I'm sure you can pick out 1 or 2 or 5 or 10 or 20 people who are released and commit a crime. But that shouldn't happen. And if they do commit a crime, they should be deported. I disagree with Mr. Saenz on that. But that's not what is happening here. So just stop attacking children. I yield back.
Recognize the ranking member for unanimous consent request.
Thank you. First up, I would introduce an article published by the 19th, dated January 6, 2026. 5 years after January 6, dozens of pardoned insurrectionists have been arrested again.
Without objection.
Also have a statement of Professor Patrick Wolf highlighting how our founding fathers stressed the importance of educating immigrant children. Patrick Wolf, Distinguished Professor of Education Policy and 21st Century Endowed Chair at the University of Arkansas.
Without objection.
The UC request to enter in the record a statement arguing keeping children in school protects public safety, strengthens our economy, and upholds our country's
Without
principles.
objection.
That's Professor Gerard Robinson at the University of Virginia. Another one from NYU Professor Sofia Rodriguez, that dismantling Plyler would harm children of U.S. citizens and all children in U.S. schools.
Without objection.
Also have unanimous consent to enter into the record statements from the following organizations. All for Ed on behalf of 109 civil rights organizations.
Without objection.
National Immigration Law Center.
Go through the list.
Okay, the Center for Law and Social Policy, the Century Foundation, the National Youth Law Center, the National Education Law Center, and the First Focus on Children, and the AFL-CIO.
Without objection.
Thank you.
Thank the gentlelady. I will now recognize the gentleman from Wisconsin for 5 minutes.
Thank you. First of all, I'd like to thank Mrs. Drogan for bringing up one of the great horrors our country was involved in over the last few years, and that is the huge number of sexual assaults which took place by leaving the border open. I went down to the border maybe 7 or 8 times, and I talked to the doctors who interviewed the women, kind of debriefed the women when they got to this country, and the fact that the Biden administration allowed this open border policy, complete with, by the time it was over, it must have been hundreds of thousands of sexual assaults, is really one of the low points in this country's history, and I wish we had more Democrats at the time who were able to look out for the women. I'll also point out that there are bogus studies out there claiming that these illegal immigrants are not committing many crimes. The only way they're able to come up with such a ridiculous conclusion is you look at, we do not keep track of whether legal or illegal or citizens are committing crimes. If I go into a federal prison, which is near my district, and ask how many of the inmates here are illegal immigrants, they would say we have no idea. Same thing if I talk about a county jail. So given that most of these illegals are not classified as illegals when they're in prison, that's how you get this bogus situation. I also, but I'm going to ask Mr. Rogers a question. I did not even know this in response to Mr. Harris's question. As far as who pays for people's public education, if somebody is a legal immigrant here or an illegal immigrant, do we treat them differently?
Yes, we do. So, for example, if a family were to come on a tourist visa, DHS would let them in for 6 months, and they can often extend for another 6 months. So if a family stayed here for a year under their tourist visas and enrolled their kids in public school, under the law, they would be required to pay the cost of that education here as temporary visitors, whereas the illegal immigrants under Plyler are not.
That's just insane, of course, the idea that we one more time treat people who come here illegally better than we treat people who come here legally. Now, I guess I could ask any one of you a question, but we'll start with Ms. Drogan. We obviously have way too many illegal immigrants in this country, and we have to do something to discourage just everybody from coming here. What effect does allowing people into our public schools for free have on the temptation to come here illegally?
I think it's a significant temptation, and we hear this all the time. You talked about the mothers that you've met whose children were abused and themselves abused on their journey up here. They are driven by the promise of educating their children. We hear this time and time again. So they are told, if you get here, then your children can be enrolled in the schools. And so that is what we are seeing occur all across the country, but Texas really is where many of them are entering at First Point, and they're finding locations that, and this is why we talk about the growing, Chairman Roy talked about how you have districts that started with a couple of dozen kids and they've grown to hundreds. There's communication, and they are bringing their children here to seek out a free public education.
It's interesting. I don't know the answer to this question, but I'll just see if any of you want to guess. We have a policy of giving apparently a free education to people who come here illegally. We also have a policy of giving free health care to people coming here illegally. Which is the dumber policy? Which is the one resulting in more people coming here who shouldn't be here? The free health care for all policy, more than the average American gets, or the free education policy? Anyone want to guess, Wiley?
I would say it's probably a toss-up. I did spend 2 years as a consular officer doing visa interviews in Brazil, and I personally saw people brag about how they could get free health care when they stayed here illegally. So it definitely is a draw.
Right. I did hear when I was down talking to the Border Patrol, dialysis treatment for free, time to get my free dialysis, come to America. Right. Next question we have. This idea that there's a racial element to what we're doing among people who come here naturalized, and every year about 800,000 people are naturalized legal in this country, something like 6 times the number when I was a child. Does any of you have any guess which countries, when it comes to letting people in this country or becoming citizens legally, which country they're from? I'm under the impression that if you look at the 10 countries that send the most new people here, none of them are European nations. The idea that we are a racist country is just a horrible slander against our country, and it makes one wonder about the motivation of people who do it. But thank you very much.
Thank the gentleman from Wisconsin. Thank you for his questions. And I will now recognize my friend from Missouri, Mr. Onder.
Thank you, Mr. Chairman. Plyler v. Doe is a clear example of judicial overreach with lasting consequences. What began as a narrow Texas funding law was transformed by the court into a nationwide mandate requiring states to provide free K-12 education to illegal aliens. As Dr. O'Brien and Mr. Rogers testified, this was not a constitutional interpretation, this was judicial legislation. In doing so, the court intruded on Congress's exclusive authority over immigration and imposed significant ongoing costs to taxpayers. When unelected judges create policies of this scale, voters and their elected representatives are left without a meaningful voice in the decisions that directly affect their schools and their children's education. As the Dobbs framework actually offers a clear outline for reconsidering Plyler, as Mr. Rogers pointed out, Plyler fails all 5 Dobbs factors for reconsidering precedent because it was egregiously wrong from the outset. And as Ms. Drogan testified, Plyler's downstream effects extend beyond illegal alien students. Schools are forced to operate without critical information about student populations and are unable to collect immigration status data that would inform resource allocation. It's time for Congress to reclaim its constitutional role and end this era of immigration policy dictated by unelected judges. Taxpayers are tired of bearing the financial burden of judicial mandates, and states need to be empowered to allocate resources based on their unique needs and the needs of all American students. Ms. Drogan, it seems to me ironic that my Democrat colleagues are somehow claiming that Democrats are standing up for these children who enter the country illegally. 300,000 unaccompanied minor children entered this country under the Biden-Harris administration, while Democrats in Congress cheered them on. Many of those kids were lost. In fact, the Biden administration lost at least 85,000 children. And some of these children were released to guardians at an address that didn't exist, or dozens of them listed to, Uncle Jose at the same address. Many of those kids are undoubtedly being trafficked to this day. Many are probably dead. What do you say to this, the idea that somehow, the Trump administration or we Republicans in Congress are somehow being cruel to illegal aliens?
It's incredibly cruel to lure children and parents to the United States, to send them through violent situations with coyotes that rape them, harm them, other violence, and then put
And
them
this goes on. This is undisputed.
This is undisputed. In
Women
fact,
and children are raped by coyotes, and my Democrat colleagues encourage this. And the Biden and Harris administration encouraged this.
yes, the policies that encourage families to come over here with the promise of a better life, or freebies, if you will, that does encourage them to go through that. And then, of course, as you noted, I think it's the Department of Homeland Security said that there were hundreds of thousands that they could not find.
Yes.
So, yes, this is a huge problem. And I know that a lot of times some want to use feelings over facts. The
Yes.
reality is that facts are being hidden intentionally. As I mentioned in my testimony, the Obama era administration, the Department of Justice and Education, worked together to send out their Dear Colleague letter, implying, just like they did with disciplinary measures and transgender ideology, that you would be investigated if you did not play our political game. And so, yes, that is what is happening here.
Thank you. Mr. Rogers, I've heard over and over again in this hearing, illegal aliens are taxpayers. Are all illegal aliens taxpayers?
No, obviously, a lot of them are paid under the table in a very significant tax.
The first time this ever came to my attention is when I was running for state rep in 2006, and I started knocking on the doors of actually union. I was in a neighborhood that was predominantly union households, and they started asking me, what are you going to do about illegal immigration? Because in O'Fallon, Missouri, a low-income housing tax credit funded project was being staffed by illegal aliens who were working off the books. The O'Fallon Police Department busted dozens working illegally off the books. I don't think we have any idea what the true magnitude of that is.
Correct, we don't, because the studies that talk about benefits cherry pick the data. Clearly, there's significant costs that aren't being accounted in those studies.
Thank you. I yield back.
I thank the gentleman from Missouri, and I want to offer my apology to the ranking member. I went out of order, believing that she had already gone, as that is my fault, and she was gracious in allowing Mr. Honor to continue his questions, and I will now recognize the ranking member for her 5 minutes.
Thank you. Mr. Saenz, you mentioned earlier that much of the discussion we've heard today has been based upon a conflation of ideas that all students from immigrant families who require ESL are undocumented in this country. But we know that almost half of foreign-born U.S. residents are, in fact, citizens. Another 19% are legal permanent residents who could become citizens. Another 5% are here on temporary visas, and half of the remaining, about quarter of foreign-born immigrants living in the U.S. have some legal status, including awaiting a determination of their asylum claims or U visas, temporary protected status, DACA status, humanitarian relief, et cetera. So we're actually talking about a very small number of our total immigrant population who are, in fact, undocumented. And when we talk about the children of those folks, it becomes even smaller. As a former school board member, I am concerned about the idea that we're going to put the burden on our school districts of determining immigration status when our federal government has such a hard time determining that, and also the burden of remedial education that would occur if we deny basic education services to children at formative parts of their lives. Can you talk about the impact on a child's life if they are denied an education and what that's going to mean to our communities as well?
Well, first of all, I think it is important to note, as you do, that all of these programs would continue. English learner programs, remedial education programs, all the programs that are being somehow attributed to the undocumented population. Because it is so small, it would have to continue in order for public education to succeed. Indeed, the incremental cost of adding one more English learner to an English learner program is much, much smaller, obviously, than having to create a new program, which is not what's happening. But what happens over the course of a child and then an adult's life who does not get a basic education is they end up illiterate in all likelihood, And the options for those who are illiterate are quite limited. Too often, the options are ones that are against the law for many. For others, they will have to, as you've mentioned, have to find some way to become literate. So you would have to see some huge increase in adult literacy programs in order to create a workforce that's even capable of doing the most menial of jobs. The alternative, as you know, is to ensure that every kid has an education and can go on beyond 12th grade if that's their inclination and their talent allows it, to make the kinds of contributions that we've seen from so many formerly undocumented immigrants ongoing in our society today.
Thank you. You touched on something that I think we all saw during the COVID crisis, that when schools closed down and kids are not in school, we saw a huge spike in gun violence and community violence that was impacting kids, either because they were unsupervised, not getting an education, or because they had too much time on their hands. Can you talk about what excluding kids from school could do to our communities? And in particular, I'm a little surprised that this pro-crime policy is something our colleagues have expressed interest in.
I had the great honor of representing the plaintiffs in challenging California's Proposition 187, which is the only direct attempt to contradict Plyler in the 44 years since. That was only 12 years after the decision in 1994. And what we found was police chief after police chief after police chief who would testify that what would happen when you have hundreds, thousands of kids on the street is they are likely to become the victims of crime because they're readily available. And too many of them, as they age, would then be fostered into becoming participants in the criminal rings that they were first victimized by. And it would result in a huge increase of crime almost immediately once you have those kids out of school. But as I've said, it multiplies over time because ultimately it's not just the kids who are excluded who choose not to be in school. Their siblings, citizen younger siblings of undocumented older siblings, will follow them out of school at some point, many of them. Others are friends. Others are even acquaintances who see, if they don't have to be in school, then why am I here? And that, frankly, will be accelerated by the withdrawal of all of the supports that is happening this year and next, whether that's healthcare, nutrition, or housing. That's going to lead to more kids' inclinations to be out of school. So if you start with eliminating Plyler, it will multiply quickly under the current regime because of that lack of support. A huge spike in crime.
If we accept that the argument that immigration status can be used as a reason to deny public education, where does that logic stop?
Again, it means that you are then allowing local decision makers to decide who they'd like to exclude from school. It's likely to start with those who are somehow different from the norm or are somehow more expensive in someone's views to educate, and it could lead to a serious decrease in eligibility for public education that the Supreme Court noticed in another important case, Brown versus Board of Education, is so critical to preserving our democracy and preserving our ability to thrive as a society.
Thank you. And Mr. Chairman, I have one last, I hope, unanimous consent request. February 6, 2025, PBS article entitled, "Who are the immigrants who come to the U.S.?" Here's the data.
Without objection.
Thank you.
And before I start my time, I have a UC request. Insert an article by Laura Reese, the Heritage Foundation, "Every State Should Challenge Plyler v. Doe, Time to End Free Education for Illegal Alien K-12 Students," without objection. And with that, I'll begin my 5 minutes of questioning. And I would note, Ms. Drogan, just quickly for you, is child mutilation in the context of transgender surgeries good for children?
Absolutely not.
Is child migration in which the coyotes are abusing these young girls and children good for children?
No, it's not.
Did disastrous open borders policies result in children being abused in the migration process?
Absolutely it did.
And this notion of not being in school being somehow a time when children would get in trouble, being in danger, even if you concede that potential reality, is the problem of the not being in school, or is the problem being here illegally?
Being here illegally.
Right. Isn't that the condition precedent? And so this whole question here about, well, we're going to be allowing local decision makers to make arbitrary decisions about who can be educated. Are we not talking about that it's not arbitrary? We're just saying that it should be American citizens or people who are legally present in the United States, correct?
100%.
So now all of this here, we've been talking about policy. We've heard a lot of my Democratic colleagues, we've heard Democratic witnesses in this hearing and in others acknowledge on the record, open without shame, that local law enforcement should not cooperate with federal authorities. We've heard that here today. We've heard that illegal alien children who have committing crimes should not be turned over to ICE for dealing with their possible deportation. We've heard that sanctuary cities for 31% of the population are good. And we've heard that there is no limit that would be accepted for how many people should come to the United States when we have 2.4 billion school-age children around the world. So my question here is, all of that seems to be the policy positions of my Democratic colleagues and those that are testifying on behalf of my Democratic colleagues. But I think the question here at the core of this is a legal question, right? And that I'd like to turn to Mr. O'Brien and Mr. Rogers to close, is that my Democratic colleagues and witnesses have said effectively in an exchange between the ranking member of the full committee, Mr. Raskin, the witness, and I'm going to paraphrase, that Plyler didn't change any status. The result of Plyler wasn't to change a legal status, but it does effectively say it would be bad. It would be bad for kids who are here illegally. Isn't this effectively, Mr. O'Brien first, Mr. Rogers, an admission that Plyler should be struck down? That this was effectively a policy choice by the court, not a legal decision baked in or based upon the 14th Amendment. Mr. O'Brien first.
Yes, the court essentially says that in its opinion. It admitted outright that illegal aliens is not a suspect classification and that there is no right to a free public education. Therefore, there shouldn't have been any issue before the court at all.
Mr. Rogers, can you extrapolate upon that?
Yeah, it's absolutely a policy judgment, and if judges have concerns about policies in America, they should run for office, but it's not their role to make policies as judges.
Correct, because there's been a lot of policy discussion in this hearing. But the question here is, as I put in the record, that Heritage paper saying, these states should be able to proceed with their policies and that Plyler should be struck down, this should be left to the states to decide, or Congress to make policy. And Mr. O'Brien, you referenced, the majority found that the Texas law imposed, quote, a lifetime hardship on children with no responsibility for their immigration status, taking an estimable toll, and the Texas interest, quote, in the preservation of the state's limited resources for the education of its lawful residents did not outweigh the harm. The court made a policy choice.
Yes,
correct?
100%.
They literally wrote out, in their opinion, a policy choice and preference. They did not root it in the Constitution or the law, as frankly was the standard of the day in that time. Right, and we've already gone through, Mr. Rogers, as you acknowledged, in the Dobbs decision, laying out how we go back and review precedent. It is your position, correct, as you stated here, but I want to summarize and close, that you think that the court should review it, that they would have, under the Dobbs framework, the ability to review that precedent, and especially in light of the error that was found in Dobbs' opinion and review of Roe, that we've got a similar legislating from the bench problem, a policy choice that was made by judges to assert in a 5-4 opinion that the people of Texas could not make a decision on their behalf for their schools, for their education, for their taxpayer dollars on how to deal with the failure of the federal government to secure the border and inundate our schools with people who are in the United States illegally. Do you believe that the court should review it based on what I just described?
Absolutely should review, and it should overturn Plyler. We've heard testimony about all the benefits from Plyler, but it's not a court's role to determine the financial benefits. That's for legislators to weigh, and that's where this should belong, in state legislatures and in Congress.
And in closing here with 7 seconds left, you believe that if brought to the court, to the Supreme Court, if states were to take action, I know Mississippi, Texas, and other states have been taking action to act on their behalf and pass policies, you believe that if taken to the court, that this court would in fact overturn Plyler and side with the states?
I do.
Well, with that, I now have my friend from Texas who has joined us here, and I would recognize Mr. Hunt for his 5 minutes.
Thank you, sir. Thank you, Mr. Chairman. Under the Biden administration, American students and parents were overlooked. This is a fact, and we all know it. President Trump took decisive action to prevent illegal aliens from receiving free secondary education, which, by the way, is a very good thing. Now, we must also prevent illegals from accessing any taxpayer benefits, including K through 12 education. As someone who was a product of school choice, me, whose parents drove me 1 hour each way so I get the education that they worked hard for me to actually attain and earn, I understand the importance of this hearing and the need to ensure opportunities are available to all American children who are tax-paying American children and tax-paying American families. Under zero circumstances should illegal aliens receive benefits that American families rightfully deserve. In the 1982 ruling in Plyler versus Doe declared that the 1975 Texas law denying funds to public schools that enrolled illegal aliens was unconstitutional because it caused lifetime hardships on children who are not responsible for their immigration status. But what about those legal citizens in this country that are also being overlooked, specifically in Texas, my home state? During that case, it was argued that only a small number of students were illegal, suggesting this ruling would be insignificant. This decision was flawed then and has become a harmful burden to the American youth today. The situation under Democrat control and what was the border crisis with over 20 million people entering this country, we have no idea who they were, and benefiting from the efforts of hard-working Americans. And as we have discussed ad infinitum today, we are in so much debt that we can't even figure out how to get out of it. And the debt clock gets worse and worse and worse, and we simply flat out can't afford it. Somebody has to have the backbone, and somebody has to have the ability to call this out for what it is. Raises a very serious question. What could this money have done for American families? What could this money have done for American students? And as somebody who is a believer in Christ, as somebody who believes in the good of America, as somebody that has fought for this country, as someone that has risked my life to defend this great nation, I understand the need to want to help others. But oh my gosh, what about our own American citizens that are tax-paying Americans right here, right now, that should be put in first place? That's what this whole America First movement is all about. This is what I fought for. And while I wish we could save the world, unfortunately, that's just not going to work. So we must protect ours first, just like any other country in the entire world would. You see, last I checked, I haven't seen any other country giving Americans piles of cash. But yet we are the ones that are shipping our billions of dollars of hard-earned tax-paying dollars to everybody else. And no one wants to help us. My first question is for you, Ms. Drogan. Thank you very much for being here today. Thank you for your testimony. And as a product of school choice, I want to personally thank you for your ongoing efforts in helping the future of our children. You say that Congress should consider legislation allowing states to collect and share immigration data for educational planning. Can you expand upon this, and in your opinion, what should be done with states that refuse to participate?
Yes, well, as I talked about, the Dear Colleague letter that essentially threatened districts or states for collecting it, that was the implied chilling effect of the letter. And the problem, obviously, there is you have educators, you have educating leaders that are afraid of this. They're afraid of the ramifications all across our state, all across our country, and so they're not collecting this data. And therefore, every time that we hear someone give statistics, whether it's how much they supposedly contribute, it's erroneous because it's not based in facts. We literally don't know, but we can estimate. We can estimate how much this is costing. We can also go back and look at the students. While English second language or emergent bilingual is not a perfect description of students that are likely here illegally, it gives us some sort of idea of what's happening. And what is happening is these students in these districts are causing negative ramifications across the board, whether it's in their classrooms, in their schools, in the entire districts that we are seeing being taken over by the state, and that disrupts all of the education. So it is a crisis to not identify who these students are. We do it with special ed. We even do it with incarcerated parents. It's just common sense to say, who are the kids in our schools? And of course, we're not doing that now, and that creates a huge crisis, both on resources and on funding.
This is an issue of opportunity cost. If we are not helping American students, we're helping illegal children of illegal aliens that shouldn't be here in the first place. It means we're not helping an American student that deserves it.
That's right.
This is not a difficult concept. It's actually quite easy. No, I'm not a jerk. No, I'm not xenophobic. I believe in ensuring that we educate American citizens first. That's where our resources, it doesn't need to go there. It must go there. Thank you very much. My time is up. Thank you, Mr. Chairman.
I thank the gentleman from Texas. I thank the witnesses for their testimony. This concludes today's hearing. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And without objection, the hearing is adjourned.